discussing features of parliamentary government. We have discussed the basics of parliamentary government, presidential government, difference between parliamentary and president government. So, we will continue with our basics. So, these are the features of parliamentary government. We have in parliamentary government both nominal and real executive. When we say nominal executive is just a ceremonial executive. So, nominal is ceremonial. So, in our parliamentary democracy, we have president as a nominal executive and prime minister as a real executive. So, what is nominal executive? Here when we say president of India is the head of the nation, that is head of the state, and prime minister is the head of the government. So, here nominal executive is president of India. He is the nominal head and real head is cabinet or council of ministers headed by prime minister. So, prime minister is the real executive in parliamentary form of government. We also call this as de jure and de facto. De jure and de facto. So, de jure is the nominal head or ceremonial head in our parliamentary system, and real authority, real power lies in prime minister. As we know, we have opted for parliamentary system of government, and in parliamentary system we have a elected body, council of ministers. A council of ministers is headed by the prime minister. Prime minister is one among all those MPs, but because he is a leader of the party and also leader of the parliament, the prime minister has the real hold on the government, on the policies. He is responsible to the parliament, and as we know, president is not directly elected by the people. So, obviously, if the president had been directly elected, there would have been a conflict of interest. So, both the prime minister and the president, if they are both directly elected by the people, definitely there would be a conflict of interest between them. So, the constitutional framers or the fathers of the constitution has thought that let the president be the nominal executive, because for the parliament, as a fact, the parliament consists of Lok Sabha, Rajya Sabha and the president. So, if a bill to be passed and if a bill to become an act, it has to pass in both the houses, and the assent of the president is also needed. So, parliament consists of Lok Sabha, Rajya Sabha and the president. Here the de jure head is the president, who is nominated, who is also elected but indirectly. President is elected indirectly by a single transferable vote, that is there is a separate electoral college for the election of the president. And real executive is prime minister, who is directly elected. He may also be nominated from the Rajya Sabha. So, we have members of the Rajya Sabha. There are many prime ministers who also been members of the Rajya Sabha. This is not in the case of Britain. It is only in the case of India, where a member of Rajya Sabha can also become a minister or prime minister as well. So, this is the important feature, having a nominal head and real head. Second is majority party rule. See, we have a parliamentary type of democracy, a representative form of democracy, where we have multi-party system. Earlier we had a single party system after elections, which was almost powerful. Single party in sense there were also parties, but Congress was the powerful party. But no, gradually there are many parties, even regional parties got evolved. So, majority party rules. In our representative form of democracy, any party who gets the majority in the house would form the government. So, gradually there were many instances where no party could have a clear majority to form the government. In such cases, the government can be formed by coalition of different parties having similar ideologies. So, the party which could not bring a clear majority can combined with other parties to form the government. Obviously, those governments were not stable, but still we had evolved in forming a government with coalition of different parties. So it's also a good thing. It's also evolving of our democracy. We are becoming more mature in that sense. So in parliamentary democracy, in parliamentary form of government, any party which gets majority in the house of the parliament would form the government. So we have seen earlier post independence, immediately the Congress has formed the government. 15 years it got existed. So there was no problem with the single party. Then slowly Morarji Desai government, which could not give a stable government. Then again we know VP Singh, Chandrasekhar, I.K. Gujral. So these prime ministers could not form a government based on the majority, and they were very short-lived. There were also problems with coalition form of government. But if the government has a clear majority, then that government would function for its full term, that is term of 5 years. Now in this case, now we have a very clear majority in the house and we have a stable government. Collective responsibility. The entire system of parliamentary government rests on collective responsibility. When we say collective responsibility, already we have discussed that we have a system of dual executive, that is the legislatures are themselves executive. So here the ministers are also the members of the parliament and they are also heading the executive. So they should have a collective responsibility and they are responsible in general to the Lok Sabha, in general to the parliament and in particular to the Lok Sabha. So there have to be a collective responsibility within the members, within the members of that party or that government. No one could just get away saying that this is not my ministry or this is not my subject. So every minister, the members of the Council of Ministers or the cabinet ministers should be collectively responsible. Otherwise, there may be a chance of dissolving of the government. The government may get dissolved if the no confidence motion gets passed in the Lok Sabha. So collective responsibility is definitely a bedrock to the parliamentary form of government. So Article 75 says that there have to be a collective responsibility. If the government could not survive, then there might be a reason where there is a bill or a motion introduced in the Lok Sabha, in the parliament, and if that no confidence motion gets passed, the government would get dissolved. So collective responsibility is the bedrock of parliamentary form of government. Another feature of parliamentary form of government is political homogeneity. Here when we say political homogeneity, this means the entire executive, all the Council of Ministers, in general, if that party got majority in forming the government, so all those members would come from same political party, having same ideology. So when we say political homogeneity, that is the ideology which runs the party gets contested and that fights in the election, and if that party gets majority, they will form the government, and the leader of that party or the prime ministerial candidate would select the important persons in Council of Ministers and they form the government, and these Council of Ministers will become part of the executive. So generally the thought is, if there is a single party which gets the majority and forms the government, it gives a stability to the government. That is, the thought process or the ideology would be very similar, so that there is no threat to the term of that particular government. So there is a political homogeneity. But in between we have seen there were no clear majority given to any party, and there was a trend of coalition politics. We have seen that there is a trend of coalition politics. We may generally see that we have NDA government, that is National Democratic Alliance government. We also have UPA government, United Progressive Alliance. So these are the coalition bodies where if any single party does not get the majority to form a government, the similar ideologically similar parties would come together and they form the government. There are many other parties who also support from the outside, not including or not participating in the government. So there are many such instances. For example, we have Communist Party. Generally, it has a different ideology, but to give a stable government, the Communist Party would also support the ruling party from outside. So when we say political homogeneity, whoever are the members of that party who wins the elections and come into the parliament would generally have a similar thought, and that would give the government a sense of stability for continuing to its term. So political homogeneity, which is very important in the political system or party system, is also a feature of the parliamentary government. As we say, we have a double membership. Again, this double membership is reflecting that a member of the parliament is also a member of the executive. Whoever wins the elections and get elects to the parliament will also be the member of the executive. That is, a person is both the legislature and also an executive. Here we can say that if any person who is not the member of the parliament can also become a minister or part of the executive, provided that he or she should get elected within 6 months from the date of acting as an executive or a minister. So this is the provision we have in our constitution. This provision we do not find in any other constitution, especially in Britain we do not have this. So any person can also become a minister, but within 6 months he or she has to get elected to the either house of the parliament, maybe Lok Sabha or maybe Rajya Sabha. So a person here is primarily an elected person to the Lok Sabha or maybe nominated to the Rajya Sabha or elected to the Rajya Sabha. That person should only be a member in the executive. So that is the meaning of double membership. We have same person acting as a legislature and also executive. As we know, Prime Minister, when we say parliamentary form of government, many political scholars, many political thinkers have also said that the Prime Minister is very significant person in entire parliamentary form of government. As we know, we call presidential form of government, and parliamentary system of government is also called as prime ministerial government, because we know Council of Minister is an executive body, it's a decision making body which is headed by the Prime Minister, and Prime Minister is also the leader of that party. Prime Minister is also the leader of the parliament. So definitely the Prime Minister has a lot of significant role in parliamentary form of government. Prime Minister is the highest executive authority, he is the real executive. So this parliamentary form of government is also called as prime ministerial form of government. So many generally we call Prime Minister as one among all the MPs, but some call that Prime Minister has very important role. He is not one among equal, he is more than that. So definitely in these years we could see that Prime Minister has yielded much power within its hands, and he could influence, the Prime Minister could influence the entire Council of Ministers too. So Prime Minister obviously plays an important role, and he is the leader of the parliament who got a good power within the member of parliament, and he would influence the policies of the government. So prime ministerial form of government is also been referred to parliamentary form of government. Here when we say dissolution, generally as we have bicameralism in Indian parliament, we have Rajya Sabha, which is upper house, and we have Lok Sabha, which is directly elected by the people. So the Rajya Sabha is permanent body. As we know, Rajya Sabha is permanent body. Every person elected to the Rajya Sabha has a term of 6 years. So we know Lok Sabha is a body which is a powerful body in the parliament. But if there is any loss of majority, or if the government could not prove its majority, the Lok Sabha could be dissolved, or the Prime Minister could also ask the President to dissolve the House, and then they could go for elections. So the Lok Sabha is not a permanent body. Lok Sabha runs only until there is a sufficient majority. There is the majority or confidence in the lower house. So the dissolution of the Lok Sabha can also be happen when the government loses its majority. It may be due to various reasons. Might be there be a defection of members to other parties, or in between the support can be withdrawn. In the coalition politics, the support could be withdrawn by other parties. So there may be various reasons, or the opposition party could introduce no confidence motion in the Lok Sabha, and if such motion is passed, then definitely the government loses its majority and the house gets dissolved. So Lok Sabha is subject to dissolution, and Rajya Sabha is a permanent body. Rajya Sabha cannot be dissolved. So this is also a feature of parliamentary form of government. Secrecy, this is a very important thing, because as we know, the important policies or important strategical policies formed within the government, and all the ministers will generally take the oath, and secrecy is very important in parliamentary form of government. Most of the ministers are involved in very strategic decision making, so they cannot just open their mind, and that is why we know the cabinet meetings are very important. Cabinet meetings are very strategic meetings where highest level decision making would generally evolve. So secrecy is not opening their mind in front of the common people. They should have a very important or significant role to play. The members maintain secrecy, and for that they will take the oath also. So that was the features of parliamentary form of government. Now we have features of presidential form of government. We generally compare the parliamentary system with the presidential system. Presidential system is followed in United States of America, which is a pure form of system where federalism is implemented or federalism is followed. So American Constitution provides for the presidential form of government, and we need to also understand that there was a debate in Constituent Assembly that why not presidential system for India. As we know that we have already have experience of prime ministerial form of government or parliamentary form of government, because Britishers have ruled us, and we could not experiment with this new concept of presidential form of government. And we also thought that we need more of responsibility than stability. We know that presidential form of government is more stable when compared to parliamentary form of government, but presidential form of government is not responsible to the parliament. That is, in America, the president is not responsible to the Congress, that is Parliament of United States of America. So what are the features of presidential form of government? As we know, in parliamentary form of government, we have a nominal head and a real head. That is, nominal head is President of India, and real executive, that is real head, is Prime Minister of India. But here in presidential form of government, there is nothing like nominal head and real head. The only head we have is President of America. So President of America is the both nominal and real head. So he is also he decides every policy. He could choose anyone for his executive, or he may not. He generally is not responsible to the Congress. So he has all the free hand to do, and he also has a fixed term of 4 years. So we know that head of both the state and the government. So American president is both real head, that is head of the government, and he is also head of the state. In our case, in India, President is the head of the state and Prime Minister is the head of the government. But here single person, that is President of America, is head of both state and the government. The next is the American president is elected by a special electoral college for a tenure of 4 years. He has a tenure of 4 years. We have a process of impeachment where the president could be impeached for a grave constitutional mistake, but generally the president enjoys a term of 4 years because as we know, they are not responsible to the Congress, they are not responsible to the legislature, and here the president would generally enjoy 4 years because there is nothing like no confidence motion which could be introduced in the Congress or Senate. Here the president is elected by an electoral college which generally gets dissolved after the elections of the president. Once the election of the president is over, the electoral college would be dissolved. We also have a separate electoral college to the President of India, but it is a permanent body. We know the electoral college of President of India consists of the members of Parliament and members of the state legislative assemblies. So we have a special concept called kitchen cabinet. Kitchen cabinet is a very powerful body within the departmental secretaries. That is, the departmental secretaries will hold a very prominent position. The President of America have a free hand to choose anyone to be a part of his executive. So kitchen cabinet is a very core group who advises on the policies of the government. We do also in India have the concept of kitchen cabinet, where within the cabinet we have a small core group very close to the Prime Minister who advises on various policies. They may not be from cabinet, they may be from outside also, expert of subject matters, expert on international relations or expert on science and technology. As such, they can be form a kitchen cabinet. So kitchen cabinet is a core group within the cabinet which has a very significant role in advising the president in this case. So kitchen cabinet forms a feature of both presidential and parliamentary form of government. So as we know, president is free to bring anyone of his choice to form a part of their executive. So we call them as secretaries. So president and secretaries are not responsible to the Congress. Here Congress means Congress is the legislature or the parliament of the United States of America. So president, as we have in India, Prime Minister is responsible for the parliament. He is responsible to the parliament, but here President of America is not responsible. Neither president nor secretaries are responsible for the Congress for their acts. We know in India, Prime Minister and the Council of Ministers are responsible to the Parliament in general and are responsible to the Lok Sabha in particular, because most of the motions are introduced in the Lok Sabha. Otherwise, we can also say that the Lok Sabha is the directly elected body. So the parliamentarians are responsible to the people. Here the president is not responsible for his acts to the Congress. As we know, the House of Representatives is the lower house of the Congress, and Senate is the upper house of the Congress, that is Parliament of the America. And we know that in India, the Lok Sabha is subjected to the dissolution, provided that if there is any party or the government loses its majority. When the government loses its majority, then the Lok Sabha could be dissolved, or in any case, if the Prime Minister wants the President to dissolve the elections or to go for early elections, there is a chance that the Lok Sabha could get dissolved, but that is not the case with the President. So here in America, the House of Representatives, that is lower house of the Congress, is not subjected to dissolution. This is the important feature of presidential form of government. That is the reason why we call that presidential system of government gives more stability. It is not responsible to the parliament, but obviously it gives a stability to the government. As we have in India, in parliamentary form of government, there is a dual membership, as we call that as dual membership, that is the legislature is also part of the executive. Here in America, we do not have a system like that, because Congress, the members of the Congress are not part of the executive here. President of America could choose anyone outside the parliament as his departmental secretaries. So the departmental secretaries or secretaries are not part of the Congress. So there is a clear distinction between the legislature and executive, as we do not have that. We have a system called dual membership, where legislatures are only the part of executive. They head the ministry, they head the department as a political head. So we do not see there is a clear separation of legislatures and executives in parliamentary form of government. But American presidential system is based on clear separation of powers, that is separation of legislature and judiciary. We have a very interesting topic, that is federal system. ఈ టాపిక్ మనకు యూపీఎస్సిలో స్టేట్ సర్వీసెస్, తెలంగాణ సర్వీస్ కానివ్వండి, ఏపీపీఎస్సి కానివ్వండి, ఇతర ఏ ఎగ్జామ్స్కైనా చాలా ఇంపార్టెంట్ టాపిక్. స్పెషల్లీ యూపీఎస్సి తీసుకుంటే మెయిన్స్లో దీని నుంచి చాలా క్వశ్చన్స్ మనకి ఇంపార్టెంట్ క్వశ్చన్స్ వస్తాయి. ఈవెన్ ఇన్ ప్రిలిమ్ పార్ట్ ఆఫ్ వ్యూ ఆల్సో వీ వుడ్ బి ఎక్స్పెక్టింగ్ ఫ్యూ క్వశ్చన్స్ ఫ్రమ్ దిస్ టాపిక్. ఈవెన్ దిస్ టాపిక్ హెల్ప్స్ us in interviews or personality test. So we need to know what federal system is, how we opted federation, the features of federal polity, and we compare the federal features with unitary features. Now first we need to understand what federation is, then how it is different from unitary system, why India now we opted for or adopted federal polity. We also criticize the system what we have today, the system what we generally call as federation in India, by comparing it with different countries which follow pure system of federation. So we can say that India do not follow as such a pure federal polity. So first we need to know what federation is and what are the features of both federal system and unitary system. See, federation is a Latin word. This is derived from the word fidus. It is derived from a Latin word. We have a Latin word. So it's a Latin word, fidus. Fidus literally means together, to bring together. It is also, derived from the word federe. This is also a Latin word which means binding together or bringing together. Now the word federation, actually we have an original concept which generally United States of America follows. The America Constitution follows federation. Federation is where all small states, small or politically, militarily weak states come together to form a strong union. So that was the actual concept of federation. As we know, United States of America, at present we have 50 states, earlier 13 states. All these states, they have come together, they have binded together to form a strong union. There may be many reasons for that. Being military weak states, easy to conquer by other countries. So all these states have come together to become more stronger in that region. So 1787 American Constitution has followed the concept of federation. So here when we say federation, when we compare Federation of United States with India, we generally do not follow the federation as followed in United States of America. There is a clear division of power between the union government, that is the central government, and provinces, that is the states. So United States of America, as we say, they have much independence. The provinces or the smaller states have much independence. So they have dual polity, they have dual constitution, they have their own judiciary system, that is the provinces have their own judiciary system and federal government have their own judiciary system. When we compare this with India, we do not follow the American concept of federation. We follow the Canadian form of federation. As we say, the 1919 Act, before independence, the 1919 Act, that is Government of India Act 1919, have initiated the concept of federation, giving some autonomy to the provinces. In India, giving some autonomy to the provinces. Again, the Government of India Act 1935 has placed provinces under direct rule of the Crown. Though we have in India Governor General who represented the authority or supremacy in India, but we also had agents in the name of Governor who is to be a link between the provinces and the Crown. So it is not the first time after independence that we have followed the system of federation. Even before that, in 1919 Act that was initiated the concept of federation, and 1935 Act which actually have followed the concept of federation. So what we follow today is a federation based on Canadian model. So we will understand what the federation is, what are the features of the federation, features of the unitary state. We compare both government, that is federal government and unitary government. So what is federation? See, when we say federation, we need to understand that we have dual polity. We have two governments. One is at central level, that is union level, and the other is at provinces, that is state level. What we call generally in India is state government and union government. So when we say federation, there was a lot of discussion, debate in Constituent Assembly that why we use this word federation. Actually, we never use this word federation in our constitution. The Article 1, that is first article of Indian Constitution, says that India is a union of states. It's a union of states. So we haven't used the word federation. Federation, though we follow because we have division of powers, we have separation of powers. So we generally follow the system of federation, but we have never used the word federation in our constitution. Schedule 7 of the constitution, where we have divided our powers, we have three lists, that is union list, we have state list and concurrent list. So constitution itself has given power to the states, but the only fact is the United States of America, where the states have come together to form a strong union, unlike India. India is different from United States of America in this character of federalism. We, for our administrative convenience, as a single unity, India is a single unity, but based on few features, few geographical features, administrative or historical features, we have divided our single unity into smaller states, that is smaller provinces. So ours is not a federation as United States follow. So there was a lot of debate in Constituent Assembly, and Dr. B.R. Ambedkar also reiterated that our India is not a federal, it is basically a union of states. So basically the federation is where the government has at two places, one is at union level and one is at provinces level. So one government which is responsible at central, that is at a central level, will be having more powers with it. Though we have divided our powers among the states, but the main powers, like the main subjects what we generally have in union list, like defense, security, communication, these things have been provided in union list. That is, union government is more powerful regarding such subjects. And obviously the day-to-day administration like law and order, education, health, local government, these powers are given to state governments. So obviously we have divided our power between the union government and the state governments, but the important subjects which is concerning the sovereignty of India, or we can say the integrity of India, the unity of India, those subjects are mentioned in union list. And when it is mentioned in union list, it is only the parliament which could pass a bill on such subjects. So we understand that we though know that a federation, but our federation is more bent towards union, and that is the reason when we call our federation as quasi federation. We call it as quasi federation. This term is used by K.C. Ware. So now we understand that the polity we follow is not pure form of federation, but it's partly federal and partly unitary. So as we said, government at the state level, that is provinces level, will be more focusing on day-to-day administration. That is, the subjects what we have which is concerned with day-to-day administration is given or provided in state list, and state government through assembly will pass bills or acts on such subjects which is confined to such states. And if there is any subject where the union government has power or it has to bring any act, then parliament would pass such bill. So when we say federation, it is where we have a national interest, there union government will come, and where the interest or subject is local, then state governments will pass such acts. So first we need to understand the basic differences between union system, that is unitary system, and federal system. So where unitary system is, we have a pure power concentrated at union level, that is central level. When we say unitary systems, basically we understand that many such countries follow unitary system of government, like we follow in Britain, we follow in France, Japan, China. These are the countries which follow unitary system of government. And when we say federation, federations are followed by United States of America. It's a pure federal form of government. We have governments in Switzerland, we have governments in Australia which follows the pure form of federation. That is, there is a division of power between the states and the center, and union government does not interfere in the matters of state government. So they have given a lot of autonomy to the state governments. So when we say unitary system, we have single government, only union government. There is no division of power between the union government and its provinces, that is state governments. So we have only single government in unitary system. When we compare unitary system with federal system, we have dual government. As we said, dual government, that is governments at two levels, at union level and also at state level. So here constitution may be written or unwritten. we have written constitutions, we have unwritten constitutions, like we have written constitution in France and unwritten constitution in Britain. So there is an option to have a written constitution or unwritten constitution, but there has to be a written constitution in federal system of polity. So here the central government or the state government derives their power from the constitution, and for that there has to be a constitution. So no other power will be a source for the power. So the constitution is the supreme authority in our country, and the constitution itself gives the powers to both union government and the state government. So there has to be a written constitution in federal system. As we said, in unitary system there is no division of powers, because we say it is single government. So there is nothing like dividing or sharing the power with other government. When there is no other government, there is no question of sharing its powers. So when we say single government in unitary system, definitely there will be no division of power. All powers are vested in the national government, that is single government at union level, that is one government. So here we have a division of powers in federal system. Because we have dual polity, we have two governments running in the same country, and the government at provinces also decides on many subjects. So there should have a authority to pass such acts for the governance of their subjects mentioned in such list. So we have division of powers. Powers are divided between union government and state government. సో స్టేట్ లిస్ట్లో ఉన్న వాటికి అసెంబ్లీస్ అనేది బిల్స్ పాస్ చేస్తుంది. యూనియన్ లిస్ట్లో ఏవైతే మెన్షన్ చేస్తున్నాయో సబ్జెక్ట్స్ వాటి మీద పార్లమెంట్ పాస్ చేస్తుంది. అయితే ఈ డివిజన్ ఆఫ్ పవర్స్ మనం అనుకున్నప్పుడు కాన్స్టిట్యూషన్లో 7th షెడ్యూల్లో మనకి ఈ 3 రకాలుగా పవర్స్ డివైడ్ చేసిబడి ఉంది. యూనిటరీ లిస్ట్, స్టేట్ లిస్ట్ అండ్ కన్కరెంట్ లిస్ట్. సో డివిజన్ ఆఫ్ పవర్ అనేది ఫెడరల్ సిస్టమ్ యొక్క ఫీచర్. సో వీ హ్యావ్ అ డివిజన్ ఆఫ్ పవర్ ఇన్ ఫెడరల్ సిస్టమ్ అండ్ దెర్ ఈస్ నో డివిజన్ ఆఫ్ పవర్ ఇన్ యూనిటరీ సిస్టమ్. When we say in unitary system, constitution may be supreme, may be. So it is not mandatory that constitution should be supreme in unitary system, because we have only single government. For example, in Japan, the constitution is supreme. In Britain, the constitution is not supreme. In Britain, the supremacy lies in the parliament. Parliament is supreme, nor constitution and not judiciary. When we say in America, the judiciary is supreme. So in the same way, we say here definitely supremacy of the constitution. In federal system, because we say in federal system the source of power is constitution, and the constitution itself divides the powers among union and the state. So obviously the constitution has to be supreme, because it's the ultimate authority, it is the ultimate source of the power. Even union government derives its power from the constitution. We also say that the union government, that is the parliament, has the power to amend certain parts of the constitution, but in this case the constitution is supreme in federal system. We would be discussing in coming classes what is Article 368, what are the amendment powers of the parliament, how it amends, what are the methods of amendment. We would be discussing this. But in federal system, the constitution is supreme. Here the constitution may or may not be supreme. Again, the constitution may be rigid or flexible. So when we say rigidity of the constitution and flexibility of the constitution, it says that the constitution could be easily amended. So that is flexibility of the constitution. Without any interference by the states, only union government can amend the constitution. So that is a flexibility of the constitution, as we have in Britain. Parliament can easily amend the constitution. There is nothing like supremacy of the judiciary this. Parliament is supremacy. As we say, in United States of America, the judiciary is supreme. It follows the due process of law. So here constitution may be rigid in sense the constitution or the amending power of the parliament is not simple. It has to be passed by special majority. So any amendment process or any process which changes the constitution or amends the constitution should have a majority of the people giving votes. So we have three things. One is simple majority, one is special majority, and one is special majority with acceptance of more than half of the states. So that we follow in our Indian constitution. So in unitary system, the constitution may be rigid or may be flexible. But here in federal system, we should have a rigid constitution. So when we say in Indian constitution, the constitution can be amended by simple majority also. There are many such provisions which can be amended by simple majority. That is just more than half of the state. Majority of the people, if voted, the constitution will held amended. But that is not the feature of federal system. So that is giving more powers to the union government. So we consider that in a unitary characters, that is unitary system. But in federal system, the constitution should be rigid. That is, the provisions in the constitution can be amended only by special majority. So special majority is 2/3 of the majority and more than half of the total members of the house. So the rigid constitution is the characteristic feature of federal system. Here in a unitary system, we say the judiciary may be independent or may not be independent. So when we say there is a single government, when the constitution may be supreme or may not be supreme, here the judiciary also may be independent or may not be independent. But here we should have an independent judiciary. In federal system, we need to have an independent judiciary. Take the United States of America. There the judiciary is very active. They have two kinds of judiciary, that is judiciary at federal level and judiciary at provinces level. So federal judiciary does not interfere in the state level judiciary. They have independent judiciary. In our case in India, though we have an independent judiciary, but it is integrated. That is, high courts in every state works under the administrative supremacy of the Supreme Court, and Supreme Court is the apex court in India. It is the ultimate court or higher court, Supreme Court. So definitely we have an integrated Supreme Court, high courts, district courts and various other courts. So we have an integrated and independent judiciary. So this integrated and independent judiciary is not a feature of federal. In federal system, we should have an independent judiciary. This may be a question generally asked by UPSC or other state services, the features of federal polity. So independent judiciary is a feature of federal system, not integrated judiciary. So here in unitary system, we may have independent or we may not have independent judiciary. So legislatures may be bicameral or unicameral. So in unitary system, obviously legislature will be unicameral because we do not have dual polity there, dual governments, because it is a single government. A unicameral legislature would solve the purpose. But when we say in federal system, we need to have a bicameral legislature. What is unicameral and bicameral? For example, in India, in our parliament, we have two houses. One is Rajya Sabha and one is Lok Sabha. So we have two houses, that is bicameral, because Rajya Sabha represents the interest of the states, various states. So that is the feature of federal system. Bicameralism is a feature of federal system. If in any country, if there is no bicameral legislature, then there is no representation of the states. So when there is no representation of the states, we do not call those as a federal system, we call it as a unitary system. So here in unitary system, there may be bicameral or maybe unicameral, but in federal polity, we need to have a bicameral legislation as we generally have in parliament. Even in state level also, we may have bicameral. That is up to the interest of the states. That is, in many states, we have both legislative assembly and legislative council. That is, legislative assembly represented by MLAs, member of legislative assemblies, and legislative councils where we have MLCs, that is members of legislative councils. Similarly, we have at union level Rajya Sabha, which is represented by states, and Lok Sabha, they are directly elected by the people. So these are the features of federalism. So how we generally differ these features. So as we said, there are two or more levels, For example, in India, we have 3 levels. We have union government, we have state government, we also have local government, which is generally under the control of state governments, but it is also one tier. So 2 or more. So till 1992, we do not have this third level of the government, that is local self-government, or we call it as the panchayats or the municipalities, which by 73rd and 74th amendment, we have given it a constitutional status in Article 243. So we may have 2 or more levels of the government, and these government will work in their given jurisdiction. For example, mana state lo Telangana kanivandi, Andhra Pradesh kanivandi, we have governments at their own level. So they will pass any act in their jurisdiction. If the assembly passes any act, that would applicable only in that state. So only that jurisdiction. So every state can pass a bill by their legislative action on their interested subject provided in state list. So here we have a jurisdiction, but when the parliament passes a bill, that is applicable for entire territory of India because it's a supreme law. So for example, different tiers of government govern the same citizens, but some legislations which are very strategic in nature related to taxation, defense, communication, that generally parliament passes. So all these powers has been provided in the constitution. So we have the source in constitution. We say Schedule 7 of the Indian Constitution provides us the source in the form of 3 lists, that is division of powers: union list, state list, and concurrent list. So when we say the features of federalism, the union government, that is the government at top level, cannot easily amend the constitution because there lies the interest of the states also. Because it's a pure federal polity, here powers are divided between the union government and the state government. So for any change or any amendment to that constitution need to have a support of the states also. That is, the top government or the union government cannot unilaterally, without taking the opinion or without taking the support of the states, cannot amend the constitution. So here we have a lot of ambiguity because in our constitution there are many such provisions which could be amended by the central government or by the parliament unilaterally without taking any opinion, suggestion or support from the state governments. So even a new states can be created unilaterally by the parliament. For example, మన ఆంధ్రప్రదేశ్ తెలంగాణ విడిపోయింది, దానికి స్టేట్ అనుమతి అవసరం లేదు. ప్రెసిడెంట్ ఒక బిల్ పెడతారు, స్టేట్ దాన్ని కన్సిడర్ చేసినా చేయకపోయినా పార్లమెంట్లో సింపుల్ మెజారిటీతో మనము కొత్త స్టేట్స్ ఫామ్ చేయొచ్చు, బౌండరీస్ చేంజ్ చేసుకోవచ్చు, స్టేట్స్ యొక్క పేర్లు మార్చుకోవచ్చు, ప్లేసెస్ యొక్క పేర్లు మార్చుకోవచ్చు. సో అంత పెద్ద స్థాయిలో మనము పార్లమెంట్ దగ్గర పవర్ ఉంది. సో పార్లమెంట్ కెన్ ఈజీలీ అమెండ్ ద కాన్స్టిట్యూషన్, అండ్ we have many such provisions in our constitution which can be amended unilaterally by the parliament. So do we call that we have a federal kind of system? Do we follow a federal polity? Obviously no, because when parliament has such a huge power to change the names of the state or to create new states or to combine states, so definitely we are not following the system of federation here. That is why we say we are not pure form of federal polity. We are following a quasi-federal, because our most of the provisions are bent towards the union government. So here, as we are discussing the features of federation, we need to know that the fundamental provisions, that is the important provisions which are concerned for both union and state governments, cannot be unilaterally changed by one level of government. So here in federation, the union government cannot change the provisions which affects the states unilaterally. That is, only the union government cannot change. It has to be passed by the consent of states also. Even in our Indian constitution, we have few provisions where such bill which affects the federalism of the country need to be passed by special majority, and then given assent by more than half of the states. More than half of the states should support such bill. That is, once the bill is passed in the parliament, there in states also such bills should be passed. That is, more than half of the states should pass such bill. For example, when we take GST, that is goods and service taxes, that is a bill, that is an act which generally affects all the states. For example, we have a panchayat system, local government. Actually, the local government is a state subject, because to bring a uniformity in India, every state should apply or should follow the same provisions, so that we have a local self-government uniformly applied and there is no inequality in the state governments. Central government has taken that bill and it have passed by help of the more than half of the states, and then it could become an act. Similarly, when we say a unitary government, where a union government can amend the constitution unilaterally without taking any support from the states, but that is not a feature of federation. It's a unitary feature. Here in federation, the fundamental provisions cannot be amended by the union government unilaterally. So such changes requires the consent of the state government. State government should show its consent, should show its support to bring such acts which affects the state's government, that is state governments. Here courts are independent. When we have discussed the characteristic features of federalism, we have independent courts, and in federation, wherever the union government passes such acts which affects the autonomy or independency of the state governments, courts will come and it will interpret the law or the act whatever the government has passed. So when we say independent judiciary, court will obviously interpret that law, and if it is against the constitution or against the fundamental provisions of the constitution which negates the principles of federation or autonomy, definitely such laws are declared void. So such laws are not inconsistent with the constitution. Those are declared void by the court, because courts are the supreme power to interpret such law. Here in federation, we have given autonomy to the states to impose or levy taxes. Here also we have taxation at two levels, that is union government will also impose tax. Few taxes are like union government will levy, collect and distribute among the states, and we have few taxes which are levied by the union government but collected by the states, and then such taxes are given to the union and union government will again distribute among the states. And we also have a few taxes which are levied, collected and dispersed by the state government. So all these matters of revenue in federal polity, where the states have given autonomy for the power of taxation. So that is the feature of federalism, where source of revenue is autonomous, that is financial autonomy. This is an important word, financial autonomy, because in many circumstances there is a disturbance between the center and state relations on these matters. For example, there was also a lot of discussion on GST. Even many states has opposed GST, goods and service taxes, because there the central government would encroach on the financial autonomy of the states. Here the independency of the state to levy the taxes is generally taken away by the union government, only because to bring a taxation network, that is one nation one tax concept, the union government has passed the GST bill. Obviously, initially many states has opposed it, but gradually the things have fallen in places. Now we have the concept of one nation one tax in the form of GST, because the union government has given lot of autonomy in the matter of financial, the states to have taxation powers or to get the percentage of revenue which has been collected by the central government in various proportions. So here the financial autonomy is given to the provinces or the tier 2 level, that is the feature of federalism. So federal system has dual objective. Main objectives of the federal system is to safeguard and promote the unity of the country. Why we say that? Generally the integrity and unity of country is protected by the unitary form of government, but here because we have such a diverse population or diverse geographical entity, definitely if the power is centralized at one level, it may not be good for the healthier democracy, because even state has their own interest. Every state is different in terms of geography, in terms of religion, region and all. So even the states has to be given a power or autonomous to function for their administration. So here when the union government decentralizes the power or decentralizes the authority by delegating their legislative power or by devolving more finances to the states, obviously the union government will play as a big brother, where all the states will follow the suggestions of the union government, but here the union government do not interfere in day-to-day things or day-to-day administration at the state level. So that would definitely protect the unity of the country. Or if there is a power or hegemony of the union government, there would bring a revolution where the people are not happy with the way the union government is suppressing the state governments. Obviously government do not function, or the relation between the union and state will be bitter. So we have a federal system where we could safeguard and promote the unity of the country. This, why we talk about unity? Because we have such a diversity. Where there is such a diversity, there have to be decentralized polity. There has to be a delegation of authority and devolution of finances. And this is possible only when we have dual system of government. One government at a union level, which generally thinks about the strategic things, that is defense. We have communication. We have other things like international affairs and all. that it has to be with the union government, and the state government should be given power to act on its own administration. So these are the two dual objectives of federal system, to protect and promote unity and to accommodate regional diversity. As we know, we are very heterogeneous country. We have different region, religion, caste, and in caste also we have different sections. We have agrarian polity, we have industrial things. So all these sectors also need to be brought at level. So we need to have a system of federation where the union government generally give autonomy to the states to protect their diversity. So here we'll discuss the federal features of the constitution. We've generally had a brief introduction. So dual polity is there. We have two systems at two levels. As we know, in India we have polity at union government and the state government. We have a written constitution. In India we have a written constitution. The constitution is written, and that is the reason why we have such a gigantic constitution. It is very lengthy because we have added each and every provisions, be it from all the three branches of the government, that is legislature, executive and judiciary. So every detail is mentioned in our constitution to avoid ambiguity, and because the constitution is the source of the power for both union government and the state government, obviously our constitution become more bulky. So we have written constitution. We have division of powers. Mana constitution lone powers ni divide cheyabadindi. Union government, state government yokka powers ni divide chesindi. Constitution lone adi mention chesi undi. Union list, స్టేట్ లిస్ట్ అండ్ కన్కరెంట్ లిస్ట్. సో ఈ డివిజన్ ఆఫ్ పవర్స్లో యూనియన్ లిస్ట్లో ఏవైతే మెన్షన్ చేయబడినాయో పార్లమెంట్ వాటి మీద పూర్తి హక్కు ఉంది చట్టం తీసుకురావడానికి. అలానే స్టేట్ గవర్నమెంట్లో ఉన్న సబ్జెక్ట్స్ మీద స్టేట్ గవర్నమెంట్స్కి పూర్తి హక్కు ఉంటుంది వాటి మీద చట్టాలు తీసుకోవడానికి. కన్కరెంట్ లిస్ట్లో ఉన్న సబ్జెక్ట్స్ మీద రెండు, యూనియన్ గవర్నమెంట్ మరియు స్టేట్ గవర్నమెంట్ రెండు చట్టాలు చేసుకోవచ్చు. సో వీ హ్యావ్ అ డివిజన్ ఆఫ్ పవర్. We have a supremacy of the constitution. As when we have discussed the differences between unitary and federal polity, we said supremacy of the constitution. Unitary polity lo, unitary type of government lo constitution అనేది supreme ఉండవచ్చు ఉండకపోవచ్చు. కానీ ఫెడరల్ సిస్టంలో మాత్రం ఖచ్చితంగా కాన్స్టిట్యూషన్ అనేది సుప్రీంగా ఉండాలి. ఇక్కడ యూనియన్ గవర్నమెంట్ కానివ్వండి, పార్లమెంట్ కానివ్వండి సుప్రీం కాదు. మన రాజ్యాంగం సుప్రీం. ఎందుకంటే రాజ్యాంగం అనేదే మనకి ఈ పవర్ అనేది మెన్షన్ చేసిబడింది. ఇన్ కాన్స్టిట్యూషన్ వీ హ్యావ్ పవర్స్ గివెన్ టు బోత్ యూనియన్ గవర్నమెంట్ అండ్ స్టేట్ గవర్నమెంట్స్. మనం రిజిడ్ కాన్స్టిట్యూషన్ అనుకున్నాము. అగైన్ విల్ డిస్కస్ దిస్ ఇన్ వెరీ డీటెయిల్. వెన్ వీ సే రిజిడ్ కాన్స్టిట్యూషన్, ఇట్ ఈస్ నాట్ ఈజీ టు అమెండ్ ద కాన్స్టిట్యూషన్. ఇట్ ఈస్ రిజిడ్. రిజిడ్ అంటే కష్టంగా, కఠినమైన రాజ్యాంగం. ఎందుకు కఠినం అంటే దానికి 2/3 మెజారిటీ కావాలి. ఆ కాన్స్టిట్యూషన్ని అమెండ్ చేయాలంటే 2/3 మెజారిటీ కావాలి. That 2/3 majority should be again more than half of the members of the house. అది పార్లమెంట్లో లోక్సభ కానివ్వండి, రాజ్యసభ కానివ్వండి 50% కన్నా ఎక్కువ ఉండాలి. ప్రజెంట్ అండ్ ఓటింగ్ అనేది 2/3 కన్నా తక్కువ ఉండకూడదు. సో బికాస్ అలాంటి ప్రొవిజన్ అనేది ఒక కాన్స్టిట్యూషన్ని మనం అమెండ్ చేస్తుంటే 2/3 ప్రొవిజన్ అనేది చాలా కష్టం కాబట్టి రిజిడ్ అవుతుంది. సో ద పార్లమెంట్ కెనాట్ ఈజీలీ అమెండ్ ద కాన్స్టిట్యూషన్ బికాస్ ఫెడరేషన్ is there. State has to show its consent. Independent judiciary, ఫెడరల్ ఫీచర్స్లో ఇండిపెండెంట్ జ్యుడిషియరీ. మనకు న్యాయశాఖ అనేది ఖచ్చితంగా ఒక యూనియన్ గవర్నమెంట్లో మాత్రమే పరిమితం అవ్వకూడదు. స్టేట్స్ గవర్నమెంట్కి కూడా ఒక ఇండిపెండెన్స్ ఉంటుంది. సో మన పాలిటీలో ఇప్పుడు మనం చూస్తున్నాము సుప్రీం కోర్ట్ అనేది టాప్ లెవెల్ కోర్ట్. ప్రతి హైకోర్ట్ అనేది సుప్రీం కోర్ట్ కిందనే పనిచేస్తాయి. సో మనది ఇండిపెండెంట్ జ్యుడిషియరీ కాదు, మనది ఇంటిగ్రేటెడ్ జ్యుడిషియరీ. కానీ ఫెడరల్ ఫీచర్లో మనం మాట్లాడితే ఖచ్చితంగా జ్యుడిషియరీ అనేది ఇండిపెండెంట్ ఉండాలి. బై క్యామరలిజం రెండు, వీ హ్యావ్ 2 houses in parliament. So this we have mentioned in 7th schedule of the constitution. As we have discussed union list, we have discussed state list, we have discussed concurrent list. So ఈ మూడు లిస్టులు అనేది డివిజన్ ఆఫ్ పవర్స్ కింద వస్తుంది. మనము what we follow today, we have 3 lists mentioned in 7th schedule of the constitution. Because we have mentioned all this list and we have very detailed provision, even now we have no entire local self-government is also mentioned in our constitution. We have created a new schedule for local self-government, that is for both municipalities and for the panchayats. We have created a separate schedule, we have created a separate part. So, because we have added all those provisions, we have a lengthiest constitution, because the constitution is the source of power for both union government and state governments. So, the constitution, why we have a written constitution? Because we also have unwritten constitution in Britain. Their unwritten in sense the things are not codified. We have a written constitution and very detailed constitution in entire world. Our constitution itself says that what we are following, no, right from preamble, in preamble itself our constitution shows that how the constitution reflects. So, we have the structure here, in sense ours is a parliamentary form of government. The parliament, the polity we follow is a republican kind of polity. So, all those structure is mentioned in the constitution. We have mentioned that the India is a union of states. So, it is not a federal polity, we have a union of states, because we have not brought the states together by agreement as it has done in United States of America. We have divided our states for administrative convenience. So, to bring good governance, to deliver good service to the people, we have decentralized the power. Otherwise, we would be having a different polity. So, we are not binded by an agreement. So, we have structure clearly mentioned. We have organization in sense like we have parliament, we have president, we have vice president, we have all the things, all the constitutional bodies like UPSC, election commission, we have CAG, Comptroller and Auditor General, Attorney General, Advocate General. All these constitutional bodies are mentioned in the constitution, and we also have other bodies, though it is not mentioned in the constitution, but it has given the parliament, the constitution has given the parliament the power to create such bodies whenever it needed. So, all those organizations are mentioned in the constitution, and we also have powers. See, when we talk about the president, what powers the president have, what powers the prime minister have, powers of judiciary and powers of all those constitutional bodies which are mentioned in the constitution. So, the powers are also mentioned in the constitution, and we have the jurisdiction of state government, the jurisdictions of local self-government. Because all these have mentioned clearly, and it is not possible to just codify, we have to have a written constitution so that there is no ambiguity, and that is the feature of federal polity, that is written constitution. Division of powers, as again we have discussed, we have three lists: union list, state list and concurrent list. Generally now at present we have 100 important subjects in the union list. So, we have 61 subjects in state list. So, union has more subjects, and that is why we call as the system, the federal system, bent towards union government. So, both the central government and the state government can bring law on concurrent list, because union list is purely the jurisdiction of union government. State list, the subjects mentioned in the state list has a pure jurisdiction where the state can bring law, but in concurrent list both union government and state government has the power to bring law. But if there is any problem or where there is any contradiction between the powers of union government and the state government, obviously the union government's law would prevail, because union government is ultimate authority here. It will supersede the powers of the state government if the matter is in concurrent list. Again, we have supremacy of the constitution. As we said, in federal polity, the constitution is supreme, not like Britain where the parliament is supreme. but here supremacy of the constitution would ensure that even the provincial governments, that is the state governments, would act in their own interest, not having or causing harm to the sovereignty of the country or unity, integrity of the country. The state can make laws within their jurisdiction for day-to-day administration. So ultimately, we need to know that the unity and integrity of the country should be protected, which obviously is in the hand of the union government. But here the constitution is supreme. So the organs of the government, legislature, executive and judiciary, all these three organs would function under their mentioned jurisdiction in the constitution. So we have legislature, we have part 5, everything is mentioned there. We have executive, even executive, that is what is executive? As we know, we have a dual role, because the people elected or the representatives elected directly by the people, those people only would be a part of executive, unlike in America where the member of parliament are not part of the executive. So we have a different thing, like American state or the USA follows presidential form of government. India follows prime ministerial form of government, as we generally know, borrowed from Britain. So here in legislature, the same people will be a part of executive, that is cabinet. We have a cabinet form of government. So the elected MPs will be a part of cabinet, and the cabinet is the highest decision making body. And we have independent judiciary. We have Supreme Court, we have High Court, we have metropolitan courts, district courts. So other such courts would have a separate organ. So all these organs of the government will derive its power from the constitution. So ultimately supremacy of the constitution prevails here in India. In British, parliament is supreme. So supremacy of the constitution is a federal feature. Here a rigid constitution, as we have discussed, for rigid constitution, that is the constitution should be amended by 2/3 of majority. That is, we have called this as a special majority. So this is special majority. Unlike simple majority, where the members sitting in the house and more than 50% of the members give support to such bill, it will become an act. So it's very simple to amend a constitution having a simple majority. In rigid constitution, we need to amend the constitution by 2/3 of the people present and voting, and that 2/3 of the people present and voted should be more than half of the total member of the house. So that is a rigid constitution. So it is bit difficult, and that is the reason why United States Constitution has been amended very few times, and we could see Indian Constitution, it's been amended many times. So we could easily say that the 42nd Amendment is called a mini constitution. So many provisions has been amended by simple majority, because our constitution is not rigid. Many provisions of the constitution, excepting few things, can be amended by the union government unilaterally, that is by not taking any support of the state governments. So the rigid constitution is the feature of federalism, not flexible constitution. So when we say rigid constitution, it is all about the method of amendment, as we generally have in Article 368, the method of amendment. We have mentioned it under Article 368. So this we would be discussing in the amendment of the constitution. It's a separate topic to deal with. So independent judiciary, this is followed in United States of America, where we have two judicial system, one is federal judiciary and one is judiciary at the states. Though we also have judiciary at the states, that is High Court in all the states or most of the states, we in High Court generally work under the administrative supervision of the Supreme Court. We have apex court, that is Supreme Court, which is the ultimate protector of the constitution. Under Supreme Court only we have all these courts, high courts and district courts. So right from their appointment, transfer or any administrative matters should be under the supervision of the Supreme Court. That is not a federal feature, I am saying. Again, India does not follow a federal feature when it comes to the judiciary. We have integrated type of judiciary, but the federal feature is where we should have an independent judiciary as we have in United States of America. So it is headed by the Supreme Court. Here Supreme Court's main function is to protect the constitution or to interpret the constitution whenever any law is passed by the union government or the state government, and if such law or against the constitution or if such law invalidates the constitution, then those are declared as void. They are not inconsistent with the constitution. So to protect the supremacy of the constitution, we have the power of judiciary, that is called judicial review. The judiciary will become proactive and it will jump into the action to ensure that any law passed by the legislature should not be against the constitution. So that is independent judiciary. It does not work under legislature or it is not below executive. It is completely independent. So the power of judicial review ensures that the court acts in an independent way without coming under the control of the legislature. Because when we say we have a written constitution and the constitution is supreme, here it is the judiciary which protects the constitution and it ensures that the constitution is supreme. Whatever the power is given by the constitution to the union government, to the state government, should be in their jurisdiction. They should not bring any law which crosses the jurisdiction. So that is independent judiciary is the feature of federal polity. And here we have bicameralism, as we say, any feature of federal polity should have these things, because when we say autonomy or autonomous powers are given to the states should get representation at higher level. When we say upper house, that is Rajya Sabha, Rajyam ante state ikkada. So state nunchi oka representation parliament lo undali. Akkada parliament lo ఏ బిల్ అయినా పాస్ చేయడానికి స్టేట్ కన్సర్న్ కూడా చూసుకోవాలి. సో ఇప్పుడు మనకున్న పరిస్థితుల్లో పార్లమెంట్ అంటే లోక్సభ, రాజ్యసభ మరియు ప్రెసిడెంట్. పార్లమెంట్లో ఈ మూడు పార్ట్స్ ఉంటాయి, లోక్సభ, రాజ్యసభ అండ్ ప్రెసిడెంట్. లోక్సభలో ఒక బిల్ పాస్ అయితే ఖచ్చితంగా అది రాజ్యసభలో పాస్ అవ్వాలి. దాని తర్వాత ప్రెసిడెంట్ యొక్క ఆమోదం అవుతేనే ఆ బిల్ అనేది చట్టం రూపంలో వస్తుంది. సో హియర్ ఈ రాజ్యసభకి ఇంపార్టెన్స్ ఎందుకు ఇచ్చారంటే, మనది ఫెడరల్ పాలిటీ ఫాలో అవుతాం కాబట్టి స్టేట్స్కి సంబంధించిన సబ్జెక్ట్స్ మీద యూనియన్ గవర్నమెంట్కి ఎక్కువ పవర్స్ ఉండకూడదు, ఎందుకంటే అది స్టేట్ యొక్క అటానమస్కి వ్యతిరేకంగా ఉంటుంది. కానీ కొన్ని సబ్జెక్ట్స్ వెన్ వీ హ్యావ్ నేషనల్ ఇంట్రెస్ట్ రిలేటెడ్ టు డిఫెన్స్, interest related to integrity, or when we have other subjects which affects our foreign relations. So such subjects have should be helped or given support by state governments also. So here we have Rajya Sabha, which is one of the houses in the parliament. So that is the bicameralism, where the members represents the states. But this is again when we say that when we compare to United States of America, even there we have bicameralism, but there they have given equal importance to all the states, be it geographically bigger or smaller. There will be two representatives which will be represented in the Senate, that is the upper house. But in India, Rajya Sabha members go to parliament, or Rajya Sabha members depends upon the population of such states. The larger the states, the more will be the members represented in the Rajya Sabha. So here the Rajya Sabha represents the states of Indian Federation. So obviously we need to pass a bill, and there have to be a support in Rajya Sabha also, because we have seen many bills which could not become act because it has not passed in Rajya Sabha. So that helps the protection of interest of the states also. Even the 73rd and 74th Constitutional Amendment Bill, which tried to, before that, before becoming an act, there were 64th Amendment Bill, which could not pass in Rajya Sabha. So it has an effect on the autonomy of the state. So even Rajya Sabha should give its, it should also pass the bill to make it a law. So here Rajya Sabha represents the state, and Lok Sabha represents the entire country as a whole. It is the people of India. Here nothing to do with the states. Once we have elections, elections will be held throughout the India. When we have elections to the parliament, the elections are held throughout the India. So Lok Sabha, Lok means people. So this house represents the people. Rajya Sabha represents the states. That is the feature of federal polity, that is bicameralism. So these are the important features what we have, which gives the federation more priority, prominence to the federal polity, where the power has been distributed equally among the union government and the state government. So though we do not follow the purest form of federalism, but it is also not true that we follow purely unitary form of government. We have mix of both unitary form of government and federal form of government. That we would be discussing in the features of unitary form of government. Then we compare both form of government. The doctrine of separation of powers, we also call it as doctrine of separation powers. So we have discussed the features of parliamentary form of government. We have discussed the features of presidential form of government. Then what are the advantages of parliamentary form of government, that is parliamentary system? We know parliamentary system has its own advantages, and even presidential system has its demerits. So it is not that, there was no such system evolved where we have both the merits of parliamentary system and presidential system at one place. We know that parliamentary system provides us responsibility, and presidential system provides us a stability of the government. But our constitutional founding fathers have thought that it is given more importance to the responsibility than stability, because we were very amateur state, we were very newly born country, so we need not to experiment with the thing what we have not experienced in the past. So we were familiar with the British parliamentary system, and hence we have opted for parliamentary system of government. So even in parliamentary system of government, we have many merits, and that is the reason why we are successful even after 75 years of independence. We have a very stable and responsible form of government, excepting few years in between. So in parliamentary form of government, there is a harmony between legislature and executive. When we say harmony between legislature and executive, the same thing, the dual membership comes into picture, because the executive and legislature are same. So the person who is part of executive is also a part of legislature. So obviously there may be no conflict of interest, because whatever the law is formulated and passed in the house of the parliament, that same law should be implemented by the same person, because the executive is also legislature, and by not taking the help of implementing agency, that is bureaucrats. The minister would implement those policies. The minister would be political head and bureaucrats are the administrative head, which is a implementing agency. But here why we say harmony? Because here the same person who is involved in formulating and passing the law would be supervising that such policies should be get implemented. So obviously there will be a harmony between the legislature and executive. This principle, this merit goes against the presidential form of government. In presidential form of government, we say that legislatures and executive are separated. There is a doctrine of separation of powers. So definitely this is not the feature of presidential form of government. But in India, as we have dual membership, where the legislature is also the head of the executive, so definitely there will be a harmony. There will be no conflict of interest. And we know responsible government. When we call this as a responsible government, the parliament, the members of the parliament are responsible. So whoever gets elected as a parliament, who forms the government, they will be a part of the executive, that is council of ministers or cabinet minister headed by the prime minister. And for whatever action the government takes, it is the council of minister headed by the prime minister is responsible to the parliament and to the Lok Sabha. So ultimately they are responsible to the people, because the people who got them elected directly and sent to the parliament to form the government if they have majority. So they are responsible to the government, and the government, if could not prove its majority in the Lok Sabha or in the parliament, there is a chance to get dissolved. If the majority is lost in the house of the parliament, then the government will dissolve and a separate election or another elections would be conducted, or if any party which can prove the majority would form the government. So here, unlike presidential form of government in America, the parliamentary form of government is responsible government and it is responsible to the parliament. Prevents despotism. When we say we are a responsible government, and when we also say that the executive and legislature are responsible to the parliament, definitely there won't be a sense of despotism. There won't be an element of autocratic rule. So it prevents despotism, because at any point of time, if the executive acts in such a way which is not inconsistent or not inconsistent with the parliament or the constitution, definitely there will be a opposition party which questions in the house. We have many such tools, like we have debates, discussions, we have question hour, we have short notice, we have adjournment motion, no confidence motion, censure motions. So we have many tools which could make the government to not act in a despotic way, because we already have an opposition party which on behalf of the people would ask the government on its failures. So it definitely prevents despotism, and this is not with the case of American presidential system, because in America we have a president who is both the head of the state and also the head of the government. He may in case turn as despot, because he has a fixed tenure of 4 years and he is also not responsible for the Congress. So definitely there might be a chance of turning despot. But in India, we generally do not find this. If there is a party which got ultimate majority, there may be some chances to turn, Prime Minister could turn as a despot, but otherwise, because parliamentary system of government is a responsible government, is responsible to the Lok Sabha and it's responsible to the parliament in general, so there is a less chances to become a despot government. We have ready alternate government. This is a beauty of a parliamentary form of government, because we know there is an opposition party, there is a ruling party, and ruling party might be having a majority, but it is not that there is no opposition party to question the policies of the ruling party. Obviously, when there are elections, there will be a verdict of few people on behalf of the opposition party also. The party which has lesser votes will not form the government, or the party which has a clear majority, or in case there is no majority, with a coalition with other parties, a party which is the largest party, which got votes as the largest party, will form the government. So the alternate is here the opposition party. The opposition party which is not ruling will be ready to form a government in case the ruling party loses its confidence in the Lok Sabha. So we have a ready alternative government. This is also an important feature. We know that in Britain we have a shadow cabinet. Shadow cabinet is we have opposition party which will act as a shadow cabinet. They will have a one-to-one cabinet ministers. So they will be ready, or it becomes a training ground for the opposition party to evolve themselves as perfect ministers in coming future. So here in our case, we say the opposition party acts as a ready alternative government. Whenever there is a majority lost in the Lok Sabha, the president would call the leader of the opposition to form the government and to prove its majority. So we have a ready alternative government, which is a merit of parliamentary system. This ready alternative government is not found in presidential form of government. We have a wide representation. As we know, the government is directly elected. The Lok Sabha members are directly elected. So obviously the leader of the party would choose an important person from all the sections of the society. He may also choose the person from different regions, different religions. That gives a secular color to the cabinet, and we have a wide representation here. So this is also an advantage, because it would create a stability or equality among the section of the society. This wide representation is also a merit of presidential form of government, where the president would choose anyone free-handedly. The president could choose anyone irrespective of the members of the Congress. So what are the demerits? Demerits of parliamentary system. The first demerit is when we have opted for a responsible form of government, that is provided by the parliamentary form of government. But as we know, both responsibility and stability do not go with parliamentary form of government. When we have chosen for a responsible government, definitely it is unstable government. Why we say it's an unstable government? Because the Lok Sabha is subjected to dissolution. In any case, if the ruling party could not prove its majority, or if the no confidence motion passed by the opposition is passed, then the government would dissolve, the Lok Sabha would dissolve, and there may be a separate election or next elections. So this concept is a demerit of parliamentary form of government. Though we know that in parliamentary form of government, the government is responsible to the parliament, but it is not stable. So there is one drawback of the parliamentary form of government. And because the government is unstable, generally there may be chances of discontinuity of the policies, because if a government is elected and if that government runs for 2 years and launched many programs, and what if that government dissolves by losing its majority in the house, those policies may not be continued with the new government. So there may be a chances of discontinuity or no continuity of the policies. This we have seen in many cases. When Indira Gandhi has lost elections and Morarji Desai has become Prime Minister, then Morarji Desai has brought many policies. Again, after losing of Morarji Desai, which was a short-lived government, Indira Gandhi has come to power, and she have again discontinued what are the policies the previous government has brought. So we could generally sense that where there is an element of dissolution of the Lok Sabha, or when any one party did not got the majority to form the full government, may have problems of not continuing their policies. So this is also a demerit of the parliamentary form of government. So this is dictatorship of policies. Dictatorship is, see, when there is a majority, there is a clear majority in the house, there is no need of opposition, or notwithstanding to the questions or pressure of the opposition, the ruling party could go with its policies. That is, there may be a sense of dictatorship when a clear verdict is given by the people and the government is stable, it has a pure majority in the Lok Sabha. So in that cases, there may be a sense of dictatorship. And other demerit is we are against separation of powers between legislature and executive. We have not clearly separated legislature and executive as in the case of presidential system of government, which is followed in America. So here we are against separation because the executives are also the members of the legislatures. So this is a demerit because here the executive may not be responsible because the same person who formulates the policy will supervise the implementation of such policies. So there is no conflict of interest. Definitely there will be a lack of responsibility in giving supervision to such policies. So this goes against the concept of specialization. So demerit is against separation of policies or separation of powers. Government by amateurs. Why we say government by amateurs? We know that most of the people who get elected to the Lok Sabha may not have good educational qualifications because they need to fight in the constituency. There are many reasons, many factors to get elected. Factors like muscle power, money power. So an educated person may not contest the elections. So here we can say that governments are by amateurs. They do not have expertise in the subject, or they may do not have any idea regarding the nature of the policies. So generally, because elected persons will become the ministers, they do not have much experience. There are many people or many member of parliaments who were stalwarts, but exception is there are also few member of parliament who do not have a basic educational qualification, and such members had become ministers. They were part of the executive. So that is a demerit of a parliamentary form of government. Here we can say that in American polity, the President of America can select anyone, any expert in and taking him as a secretary. So an expert person is part of the executive. Definitely in that case, there will be a specialization. The policies would be created, formulated or implemented in a specific way. So here this is the demerit of our parliamentary form of government. So why we have adopted the parliamentary form of government? We know parliamentary form of government have its own demerits. It also has its advantages. But what are the reasons for its adoption? We know the presidential system of government, which is implemented in United States, that is United States presidential system. We have no experience of presidential form of government. As we know, since 1909, 1919 and 1935 Government of India Act, we got familiarity with the British parliamentary system of government. Gradually, we have been implemented these measures in our system or in our country. So we were more familiar, we got a familiarity with the system, the prime ministerial system, because the British is run by prime ministerial form of government, Westministerial model of government, and we were familiar with the model which Britishers have introduced in our country. So we know that familiarity is important. We did not take any chance or risk to adopt presidential system of government, which is not responsible to the Congress, but which gives a stability to the government. and our founding fathers have opted for responsibility, not stability. So, as we are familiar with this system, parliamentary system, we have adopted the parliamentary form of government. The same thing what I have said is preference is given to responsibility. Here we have given preference to responsibility and not stability. As we know, in parliamentary form of government, we have a dual membership, that is a legislature is also executive. So, we will generally avoid the conflict between legislature and executive. So, there is a need to avoid such conflict. We have opted for parliamentary system of government. Here legislative and executive do not have any conflict, because he is the same person who is a member of the parliament and is also executive. So, here there is no separation of power. As we know, we understand that this is not based on the doctrine of separation power, but here we could avoid the conflict between the executive and the legislature, which is a major bone of contention and which we could not afford because we have a very infant democratic country. And we also know that nature of the Indian society, because we have directly elected representatives in the Lok Sabha, and there were many problems like we had a lot of illiteracy, we had a lot of internal problems, like we have multi-religious system, we were not evolved, our political parties were also not that matured. So, to give equal representation to all the sections of the society and to have an equality among the nation and to protect our secularism, our sovereignty, we have opted for parliamentary form of government. And because this is nature of the Indian society which has prompted us to adopt parliamentary system of government, because our founding fathers have thought that it is not the time to experiment with some other feature which we were not familiar with. So, we have opted for parliamentary form of government. So, that was the reasons why we have opted for parliamentary system of government. Now, as we know that the parliamentary system of government we have adopted from the British model. So, we need to find the differences. It is not that we have copied all the things, all the provisions which are followed in Westminster model. We have though borrowed it, we have modified it according to the necessity and need of our Indian society. And what is the difference? What are the differences or distinction between the Indian model and the British model? We know India has a republic system. Our system is a republic. It is mentioned in the preamble also. We are a republic. Here republic in sense, our head of the state is not hereditary as we have in British, where the king or queen are hereditary nature. We have a republic system, that is the head of the state, that is the president. Anyone can become the president, probably provided he is qualified for that post. So, India is a republic system. There is no system of hereditary here. So, that is the major difference between Indian parliamentary system and Britain parliamentary system. Britain parliamentary system is monarchical and we are a republic. So, we do not have a monarchical system, that is a hereditary system. And British system is based on the doctrine of sovereignty of the parliament. British system is based on sovereignty of the parliament. In Britain, parliament is the ultimate authority, parliament is supreme. But in India, we have constitution which is the supreme authority. Constitution is the highest authority, supreme law of the land. So, we differ in this case where parliament is supreme in Britain and in India, the constitution is supreme. The constitution is the source of power for all the organs of the government, be it legislature, executive or judiciary. It is the constitution and it is the Supreme Court which forms the custodian of the constitution. And here when we say central government and state government is not inferior to the central government, because Union government and state government both derive their power from the constitution. So we can also say that we have a federal kind of polity here, and in federal polity parliament will not be supreme. It is the written constitution which forms the source of the power to all those organs of the society. So in British system where parliament is supreme, as we know in British we have unwritten constitution, and in India we have a very detailed constitution which has a provisions of all the powers, structure and functions of various organs of the government. So in India constitution is supreme, unlike in British where parliament is supreme. So this is also a major difference. Another distinction is British Prime Minister should be a member of the lower house. This is not government, this is lower house. Lower house is House of Commons. In Britain we call this as House of Commons. In India we have lower house in the name of Lok Sabha. So British Prime Minister should be a member of the lower house of the parliament, but in India it is not mandatory that Prime Minister should only be a member of the Lok Sabha. Even the member of the Rajya Sabha can also become Prime Minister. That is, member of the Rajya Sabha, he or she may not be directly elected, but the Rajya Sabha member can also become the head of the government, that is Prime Minister. Here we have sense that even Indira Gandhi was also became Prime Minister, who was a member of the Rajya Sabha. Then Manmohan Singh was also initially a member of the Rajya Sabha who have became Prime Minister. Deva Gowda also, I think, a member of the Rajya Sabha who became Prime Minister. So British Prime Minister should be a member of only lower house, that is House of Commons. In case of India, the Prime Minister could be a member of either house of the parliament, that is from Lok Sabha or from Rajya Sabha. So again, basic difference between the Indian model and British model. In British, we know member of parliament alone are appointed as ministers. When we say ministers, they are executive. As we know that in India also, only members of parliament should be appointed or made a minister, but there is a small difference. Here we have a provision. Any other person who is not part of the member of parliament, or who is not a part of the parliament, who is not a member of the parliament, can also become a minister, provided that within 6 months he should get elected or gets nominated. He should get elected to the Lok Sabha or he should get nominated to the Rajya Sabha. So we have a time limit of 6 months. This provision is not there in Britain model. In Britain, only member of parliament could only become the minister. He should be a member of the parliament to be part of a minister. So this we do not have. We have a provision of 6 months. And this is a very important distinction between Indian and British model. When we say that system of legal responsibility, system of legal responsibility is prevailing in Britain. Here when we say the Council of Ministers headed by the Prime Minister would aid and advise the President in any executive action. That is, any executive action of the government is approved by the President, or the President is the final authority to approve any bill to make it into a law, or any action should be in the name of the President. So here there is a system of legal responsibility. Here when the President signs or the head of the state signs any order, it is countersigned by the minister. In Britain, that particular order is countersigned by the minister, and if there is any inconsistency in particular function, then that particular minister is legally responsible. This system is not there in India. In India, the Council of Ministers or the Cabinet Ministers will not generally countersign any law. So we do not have the system of legal responsibility. There might be the reason because there are many such actions where the Council of Ministers would not take responsibility, because it is the collective action of the Parliament. So a single minister may not take the responsibility. So this system is not there in Indian parliamentary system. And we also do not have a system of shadow cabinet. Shadow cabinet is an exclusive feature of British model of parliamentary system. Here shadow cabinet is, we have an opposition party, we have a ruling party, and in ruling party we have various ministers, that is Council of Ministers. Similarly, in opposition also there will be a minister who are shadow to the ruling ministers. So this gives a direct interaction between the ruling government and opposition government. So the member of the shadow cabinet would follow the member of ruling party in whatever policies they are making. So there will be a very close interaction between the ruling party and the opposition party, and they are the ready alternate to form the government in case there is any dissolution of the house. So shadow cabinet is an important feature of British parliamentary system. So this was the class. We have discussed parliamentary form of government, we have discussed presidential form of government. There is a distinction between parliamentary and presidential form of government. We've also discussed the reasons why we have opted for parliamentary system of government, and we also discussed the basic differences between Indian model and Britain model. Just to have a quick check, we will be having few questions. So the parliamentary system of government in India is based on the pattern of parliamentary government existing in, as we all know, we have taken or we have adopted the parliamentary system of government in India from Britain, because we were very much familiar with this country. They have introduced many parliamentary laws in India. So whatever the system what we are following has its roots in Britain. So Britain is the correct answer. Is based on the pattern of parliamentary government existing in Britain. Next question is, which of the following characteristics is not related to parliamentary government? The characteristics which is not related. So resolution of lower house. It's not resolution, it's dissolution. Dissolution of lower house is a characteristic feature of the parliamentary government. So we have to choose which is not the feature related to parliamentary government. So this is true. Collective responsibility, as we all know that collective responsibility is the backbone of parliamentary form of government. So this is also correct answer. Leadership of the Prime Minister. In parliamentary form of government, we have a very powerful Prime Minister, which is also sometimes referred to as Prime Ministerial form of government, and single executive. So this is not the feature of parliamentary form of government, because we have dual membership. So single executive is wrong, and here we also have a case that we have two executives, one is nominal executive and one is real executive. Nominal executive, that is de jure executive as a president, and real executive, that is de facto executive as Prime Minister of India. So single executive is not the feature of parliamentary form of government. Single executive is a feature of presidential form of government. Which of the following is not the merit of presidential system? So we need to know what presidential system is. As we all know, presidential system is followed in United States of America, and we also know that presidential system is not responsible to the Congress. It is stable, but it is not responsible. So which of the following is not the merit? Which is not the merit? Permanent government. Permanent government is merit, because we know that presidential system is stable, it is permanent. It has, president would function for 4 years of term. And confirmation in policies. As we know, the president is not responsible to the Senate or to the House of Representatives, the policies are very much in confirmation, because the Congress generally do not ask for the policies as we do have in our parliament, when opposition questions the policies, because it has to question, and because it is have a opposition status, there will be a question, counter question in the parliament. And here, as we are responsible to the parliament, it is the responsibility of the ruling party to answer the questions of opposition party. Here, confirmation is the policies is a feature of presidential system. Limited representation. This is wrong, because in presidential form of government, the representation is very wide, because the executives or the secretaries, as we call, they are not part of the parliament, that is Congress. So the president has all the freedom to choose anyone from any section of the society depending upon their expertise. So very wider representation, the president has a free hand to choose anyone as their secretaries. So limited representation is not the feature of presidential system. Government by experts, this we should agree. When we have wider representation, there might be persons who are expertise on such subjects, and they would be added in their executive, that is in their executive group. As we know, who will be the Secretary of State, who will be the Defense Secretary, those persons have expertise in those fields, and those persons would only added in their executive. So government by expert is also a feature of presidential system. Limited representation is not the feature of presidential system. Actually, this is a feature of parliamentary form of government. Is a little big question. Which of the following statement is not correct? So according to 42nd and 44th Amendment Act, it is compulsory for president to comply with the advice of the Council of Ministers. This is true, because we know Article 74 and 75 are very important in prime ministerial form of government, where article it says that the prime minister, who is the head of the Council of Ministers, or in other words, the Council of Ministers headed by the prime minister, should aid and advise the president. Here the president is binded by the advice of the Council of Ministers. That is what made mandatory by Article 42nd and 44th constitutional amendments. So here the president could not reject the advice of the Council of Ministers. It is mandatory, it is binding that the president shall follow the advice. It is not just advice, it has to be followed. So the president has to follow the advice of the prime minister, who is the head of Council of Ministers. So this is true. Presidential system is based on double executive. So this is not correct. Presidential system is not based on double executive. It is based on single executive. Double executive is a feature of parliamentary form of government. Here the President of America is both the nominal head and the real head, that is head of the state and head of the government also. So presidential system is based on single executive. So this is a wrong statement. So this is the correct answer here. We'll see other statements also. According to the Article 74, the Council of Ministers works under the leadership of the Prime Minister. Yes, as we already said, Article 74 is very important in prime ministerial form of government. Article 74 and 75 provides for parliamentary system in the center, in the union. That is also correct. So answer is this. This is a wrong statement. Moving on to the other question. Which of the following is a demerit of parliamentary system? Which of the following is a demerit of the parliamentary system? Yes, we have a compressed representation. It is also a demerit, because in presidential form of government, the president could choose anyone out of the parliament also to be added in their executive. But here in parliamentary system of government, only members of parliament should become a minister. So obviously it forms a demerit, because as we say, government by amateurs or government by not expert people. So definitely in compressed representation, we would generally have members who are not experts in the subject matter. Yes, there is an uncertainty of policies because once the Lok Sabha gets dissolved, there may be a chance that other party would form the government and the policies which have implemented by the previous government may be discontinued. So, there is an uncertainty of the policies here. Obviously, it's a temporary government, though the government has a term of 5 years, but that all depends upon the majority or the confidence which enjoys in the parliament. So, even temporary government is a demerit of parliamentary system of government, and in presidential system of government, the presidential system of government is stable. So, it has has to do work for 4 years, and the Senate is not subject to dissolution. That is, the lower house, the House of Representatives is not subject to dissolution. So, here the answer would be all the above. The separation of power is the characteristic feature of which government? As we have known, separation of powers is very clear in presidential form of government. So, in presidential form of government, the executive and legislature are separated. In parliamentary form of government, we do not have that separation of power because we have dual membership, both legislature and executive. A single person could be both legislature and executive. So, the separation of power is a feature of parliamentary form of government. In presidential, the separation of the power is a feature of presidential form of government. Sorry, it's not parliamentary form of government, it's presidential form of government. In parliamentary form of government, we do not have the clear separation of power. We have in parliamentary form of government dual membership. So, answer is B. Which one of the following is not an essential feature of parliamentary system? Parliamentary system. Fusion of the executive and legislature. Yes, this is the future because we do not have separation of power. We have fusion. Both legislative and executive are a single entity. So, we have a fusion of executive and legislature. We have nominal head of the state. Yes, president is the nominal head of the state and he is a de jure head, and prime minister is the de facto head of the government. So, this is also a feature of parliamentary form of government. Collective responsibility, again article 75 says that collective responsibility is a feature of parliamentary system. Fixed tenure of executive, this is the feature of presidential form of government. This is the feature of presidential form of government and it is not the feature of parliamentary form of government. So, answer would be D. D is answer. Next question, we have in parliamentary form of government, ministers are appointed by. Who appoints the ministers in parliamentary form of government? He is appointed by the head of the state at his discretion. No, head of the state, as we know, it is president, and president do not appoint minister. The ministers are appointed on the advice of the prime ministers. This will say the head of the government, will come back to this, the head of the state on the recommendation of the head of the government. This is true because the ministers are appointed by the president on the recommendation of the prime minister, who is the head of the council of ministers. So, this is the right answer, the head of the state. Here head of the state means it is president on the recommendation of head of the government, who is prime minister. So, the ministers are appointed on the advice of the prime minister. So, this is the correct answer.
We have a topic called parliamentary system. This is a very important topic in Indian polity. We would be expecting more questions in any competitive examination. So, basically we have a system of parliamentary democracy. We have opted this parliamentary system or parliamentary form of government, which has been adopted from the Britain, the England. So, there in this class we would be discussing parliamentary system, its merits, demerits, features, and also will compare parliamentary system with presidential form of government, which is been followed in United States of America, Sri Lanka, etc. So, here in this class we will be discussing what are the major features of parliamentary system. We had a long discussion in Constituent Assembly also, where there was the need to discuss about the parliamentary system, why we haven't opted for presidential form of government. As we all know, we have been ruled by British for 200 years long, but from 1909, that is the Act, Government of India Act 1909, we have gradually been experiencing this parliamentary form of government, and we have very much familiarity. You take 1909 India Act, 1919 Act, Government of India Act 1935. So all these major acts have gradually implemented most of the features of parliamentary form of government, which has been practiced in United Kingdom, that is England, British. So as we have a familiarity with the parliamentary form of government, and we could not generally experiment with the presidential form of government because we are a newborn country there. So we thought of sticking with parliamentary form of government. In this class, we would be discussing merits, demerits of parliamentary form of government, and we also compare this with the presidential form of government. So here in our constitution, Article 74 and Article 75, these are the major articles which establishes the parliamentary form of government at central level, and Article 163 and 164 gives the strength, or it establishes the parliamentary form of government at state level. So Article 74 is we have a council of ministers headed by Prime Minister to aid and advise the President in the running the government. So Article 74 talks about a council of ministers, that is the executive, headed by Prime Minister, and Prime Minister will be one among those ministers, but he would be the leader of the government. So parliamentary form of government by Article 74, it says that Council of Ministers headed by the Prime Minister will aid and advise the President. As we know, President is the nominal head of the nation, and Prime Minister is the head of the government. So Article 74 talks about Council of Ministers, and Article 75, which ensures collective responsibility in the Parliament. So here, when we discuss the features of parliamentary form of government, we would be discussing many such segments or components, like we have nominal head, executive, we have majority party rule. So these we'll discuss. So Article 74 and 75 forms the bedrock of parliamentary form of government. We have taken this parliamentary form of government from England. Even Canada follows the parliamentary form of government. Similarly, we have Article 163, where we generally compare that with union government. Even at state level also, we have a council of ministers headed by the chief minister, who will aid and advise the governor in the running of the state. So in modern democracies, we have two forms of governments. Existing democracies, we have two forms of government. Not only democracy, but any country, irrespective of the type of rule they have, we have two major form of democracies or systems. One is parliamentary and one is presidential form of government. So modern democratic governments are of two types. One is parliamentary government and the other is presidential form of government. So we'll discuss what the parliamentary government is. So parliamentary system here is generally we call as a Westminster model. Westminster is a place in England where the parliamentary form of government has been originated. So we also call this as a Westministerial model. We also call this as a cabinet government, because cabinet is the real executive in parliamentary form of government. What is cabinet? See, we have a council of ministers. we have a group of ministers. Within that, we have very important portfolios, important ministries like Defense, Health Ministry, External Affairs Ministry, Finance Ministry, Home Ministry, Education Ministry, Agriculture Ministry. So, all these ministries are very significant and have very important role to play in decision making. So, cabinet is a small group within the Council of Ministers. Council of Ministers is a larger group. Within that, very important portfolios are headed by the cabinet ministers. And because cabinet is a highest decision making body, or it is a very important executive body and which is a part of parliamentary system. So, we also call parliamentary system as a cabinet government or cabinet system of government. We also call parliamentary system as prime ministerial government, because as we know, prime minister is head of the Council of Ministers. He is the head of the government. He or she is the head of the government, and prime minister is the real executive. When we compare President of United States of America, President of United States of America is both ceremonial and real executive. But in parliamentary system of government, President is a ceremonial head, that is a nominal head, and Prime Minister is the real head of the government. We also call Prime Minister as the real executive and President as the nominal executive, because he just has to play a ceremonial role. He acts on the aid and advice of the Council of Ministers headed by the Prime Minister. Because Prime Minister is so significant, he could make or unmake the government. That is the reason in parliamentary system we also call it as a prime ministerial form of government. As we do in presidential system, we call it as presidential form of government. So, in parliamentary system, executive system of the government, we call this as executive system of government, because here there is no distinction, there is no clear separation of powers between the legislature and executive. Executive is part of the legislature, because who are executive here? Only those members who got elected to the parliament can only become a minister. That is, a minister, that is who heads a ministry or department, is the same person who got elected to the Lok Sabha or Rajya Sabha, that is to the parliament. Unlike in presidential form of government, or we'll take an example of United States of America, where the president can choose anyone to be part of their executive. So, here when we say the Congress of America, that is the Parliament of America, we call it as a Congress. There we also have two houses, that is upper house and lower house. Upper house we call it as a Senate, and lower house we call it as the House of the Representatives. Here in presidential form of government, the executive is not part of the Congress, that is the Parliament of United States of America. The elected president, the president who got elected, would choose anyone, any member from the outside to make part of the executive. In India, in parliamentary system of government, only member of parliament will be the part of executive. When we compare Indian parliamentary system with Britain parliamentary system, in British only the members of lower house, that is House of Commons, can be the executive or can be the part of the executive. Here in India, we can take anyone both from Lok Sabha and Rajya Sabha as well to be a part of executive. So, parliamentary system is called executive system of government. Here in parliamentary system, the executive is responsible in general to the parliament and in particular to the Lok Sabha. They are responsible, and that is the reason we call parliamentary form of government as a responsible government. In presidential system, the executive is not responsible to the Parliament of USA, that is Congress. That is the reason why we call presidential form of government as non-responsible government. So there are many merits and demerits when we look into the matter of parliamentary system of government and presidential form of government. So here in presidential system of government, we have a clear division of powers, clear separation of powers, that is among the three organs, be it legislative, executive or judiciary. But in parliamentary form of government, which is practiced in India, we say legislature and executive are not completely independent, because the executive are only those members who are the members of parliament, that is the legislatures. The legislatures or MPs can only be the person who will head the ministry or department. So we do not have a clear separation of power when it comes to parliamentary form of government. So executive is not responsible in presidential form of government, which is practiced in United States of America. Executive is not responsible to the parliament, that is legislature. They could take any action. For that, legislature or legislation in the Congress is not required. So they are independent of legislature, and judiciary is also quite independent in United States of America. Here we have independent but integrated judicial system in India. So constitutionally they are independent of the legislature in respect of terms of office. When we say terms of office, the United States of America president would be elected for 4 years. So term is fixed. Though in India, the parliamentary form of government, any government is elected for the duration of 5 years, but if there is any differences or if the majority falls, then the government would be dissolved. So we do not have a fixed term of 5 years until and unless there is a majority in the parliament. The party which got elected to form a government should have majority. We have seen in many cases there is a dissolution of the government because the House could not prove its majority. We have seen cases when there was a no majority. Here in the case of Morarji Desai government, in the case of Charan Singh government, Vishwanath Pratap Singh government, Chandrasekhar government, I.K. Gujral government. Then we also seen for few years even Atal Bihari Vajpayee government also got dissolved because they could not prove the majority. And slowly we had diverted to coalition form of governments. So the majority in the house is important to have a full 5 years of term. So there are many such features of these governments. So as I said, parliamentary system of government is also known as cabinet government, responsible government, because cabinet is the highest decision making body, very important. So a group of ministers within the council of ministers would form a cabinet, and we know council of ministers is a larger body. For any strategic decisions to be taken, it is not feasible to have consensus among all those ministers. So we have a smaller body within the council of ministers which heads very important portfolios, would form the highest decision making body, or they are the highest executive body. So we also call it as a cabinet government. Responsible government, they are responsible to the Lok Sabha in particular and parliament in general. And Westminster model, we say that Westminster model because Westminster is a place where the parliamentary system of government has got originated. This parliamentary system of government is prevalent in Britain. We have taken the parliamentary form of government from British. We have Canada, Japan and other states where parliamentary form of government is in functioning at present. We call presidential form of government as non-responsible government. Non-responsible does not mean irresponsible. Here, non-responsible means the executive is not accountable to the legislature. So, for every action, the executive is president and his secretaries, we call them as departmental secretaries. So, this executive body is not responsible to the Congress, unlike in India where executive is responsible to the parliament, because those executives are also the members of the parliament. So, their every action would be discussed in the parliament. We have many such tools, like we have many motions, we have short notice, we have cut motions, we have debates, discussions, adjournment motions, no confidence motion. So, all these are the tools like question hour. So, by this the opposition party would ask questions, and it is the responsibility of those executive or ministers, what we call, to answer those questions. Because there is a lot of debate and discussion, the executive is responsible to the parliament. Here in presidential system, there is no such responsibility. The executive in presidential system are not accountable for the legislature or Congress. So, this type of presidential system is prevalent in United States of America, Sri Lanka, Russia, Brazil, etc. So, we have to know that presidential system of government has its own merits, prime ministerial system has its own merits. Both the system has their own limitations also. We could not find a system of government where both stability and responsibility are together. When we say presidential form of government has little responsibility but more stability. In parliamentary form of government, it is more responsible but less stable. So, we could choose any one, and we have opted for parliamentary form of government, that is a responsible government. So, presidential form of government has a fixed tenure of 4 years in United States of America. In India, we do not have such fixed tenure, though the government, the ruling government can be there for 5 years, but if there is no majority, the government gets dissolved. So, we could not say that the government has a fixed tenure, that depends upon the majority in the house. So, that is presidential form of government. So, Dr. Ivor Jennings, expert in constitution, expert in parliamentary law, has called parliamentary form of government as responsible government. So, we also called parliamentary form of government as prime ministerial government, because prime minister is also a member of the parliament, he is the leader of the party, he is the leader of the house. But prime minister, when we say, he is a primus inter pares, that is one among equals, he is the first among equals. Here equals is all the members of parliament. So, prime minister, because he is the leader of that party, leader of the Lok Sabha, we call him as primus inter pares, that is first among equals. And this is the reason why we also called the parliamentary form of government as prime ministerial government, because prime minister, at least nowadays we have seen many powerful prime ministers. We had powerful prime ministers like Jawaharlal Nehru, then Indira Gandhi, then Rajiv Gandhi. We have, at present we have Narendra Modi, who are very powerful, and we cannot just say that they are one among equals or first among equals. They are powerful that they could influence the policies of the government. So, they could influence the cabinet also. So, that is the reason why we call parliamentary form of government as prime ministerial government. So, we will discuss the features of parliamentary government.
We would be discussing the unitary features. As we say unitary features, these features are not the federal features. This goes against the concept of federalism, because Federalism is where the union government and the state government are independent, are separated, division of power is there, clear division of power. Even we have a clear division of power which is mentioned in list system. That is, the list is there and we have a unitary list, we have state list and concurrent list, and union list has more important subjects, more number of subjects are there in union list, and also the residuary powers which is not mentioned in either of these three lists is within the jurisdiction of the parliament. So, to understand the Indian concept of federalism, we need to understand what are those features which forms the unitary features, that is, they are against the federal features. As we can say, we generally have two types of federation. One is holding together federation and one is coming together federation. We have a concept as holding together federation because we have a single entity. India is a single entity and we have divided our states for administrative convenience, and our states have not come together by an agreement. We voluntarily has divided the states for convenience of administration, for giving good governance. So, we cannot say that as United States have smaller states came together to form a bigger and stronger union, they have the concept of pure federalism as followed in United States of America, Switzerland and Australia. They are coming together federation. Ours is a holding together federation. What we follow is holding together of federation, like India, Spain, Belgium. These are the countries which follow the holding together federation. And Canada is such a country which we have a relativeness. We have got inspired from the Canadian concept of federalism. So, in this class, we would be discussing the various unitary features and we would also be criticizing the concept of federalism. So, first is the flexibility of the constitution. Here, when we say the flexibility of the constitution, it is the method, the method to amend the constitution or the way to amend the constitution. Is it flexible or rigid? As just to understand, the rigidity of the constitution is a federal feature. That is, the union government cannot unilaterally amend the constitution. We have a single constitution both for union government and state governments. Though we have a single constitution and the constitution is the source of power for both union government and state governments, here most of the provisions mentioned in the constitution can be easily amended by the parliament. That is, by simple majority or by special majority, most of the provisions can be amended. Here when we say special majority, we have two types. One is 2/3 of the members present and voting, and those 2/3 of the members present and voting should be more than half of the total member of the house. That is one special majority. And third is again the same thing, 2/3 of the members present and voting and should be more than total number of the houses, and that bill should also be ratified by more than half of the states. So, that is also one part of special majority. So, there are very few provisions which has this special kind of majority with the ratification of more than half of the states. Here the states have also been considered in passing the bill or in bringing any act. But most of the provisions like creating new states, changing the boundaries of the states or renaming the states can be done by a simple majority. Just you can pass the bill in the parliament, and no, by just simple majority we can create a new state. So here the state's power has been reduced. States have not been considered in most of the provisions in making law. The constitution itself has given the union more power. That is the reason most of the features are unitary features, and very few features are there which are federal features. So when we say the flexibility of the constitution, the amendment of the constitution or changing the provisions in the constitution is not rigid. Rigidity of the constitution is federal feature. Flexibility of the constitution is unitary feature. So we say the flexibility of the constitution, changing or amending the constitution is easy, and unilaterally a parliament can amend the constitution. Most of the provisions, I am not telling all the provisions, but most of the majority of the provisions mentioned in the constitution could be amended by the parliament in a unilateral way, that is by not considering the states or not taking the opinion of the states. So obviously this thing, amending of the constitution, which is mentioned in article 368, has been a matter of conflict in many things. States are not generally happy when parliament passes a bill or makes a law which is not in the interest of the majority of the states. See, what happens is when there is a ruling party at the center and not the same party in the state, so there would be a conflict of interest, and if any bill which is not in the interest of the state is passed by the parliament unilaterally without taking the opinion of the states, most of the states would feel that their autonomous state has been challenged. And there are many cases in Supreme Court also regarding this. But as we know, our constitution has given more powers to the union, and constitution is the ultimate source of authority. So generally we do not find any answer for this. Most of the critics have criticized, saying that the union government is more powerful in matters of emergency, and again in various matters like the power of Rajya Sabha, where the Rajya Sabha can initiate the parliament to make laws mentioned in the state list, to make laws on the subjects which are mentioned in the state list. So definitely there is a overriding power given to the union. Here we are talking about the flexibility of the constitution, which is a unitary feature. So here in flexibility, many provisions could be amended easily. So as we know, in SR Bommai case, the Supreme Court has clearly mentioned, though we have given more powers to the union, but federalism is a basic structure and the union government cannot bring any such law which causes any harm to the concept of federalism, then that law would be declared as void. So we have many cases regarding this, but here as we know, federalism is a basic structure as given by the Supreme Court. We generally do not tamper with the concept of federalism. What we need to agree here is union government obviously holds more power when compared to state governments in the amending powers of the constitution. That is one thing. More power vests with the center. This is true because the Schedule 7th of the Constitution, which divides the power among the states and the union government, has mentioned more subjects in the union list. As we know, we have three lists: union list, state list, and concurrent list. So the important subjects, the important subjects which has a strategic significance has been mentioned in union list. Subjects like defense, subjects like communication, which also gives very important or strategic location, strategy of the India, like we have foreign relations. So all these subjects are mentioned in the union list. Matters of election, matter regarding citizenship. So all these subjects are mentioned in the union list. Important subjects which has an impact on sovereignty, secularism, integrity and unity of the nation are been mentioned in union list. Not only important subjects, but most of the subjects, that is in numbers also, around 100 subjects are mentioned in union list, and in state list we have around 66-67 subjects. So here union list is there where important subjects are being provided, and most of the subjects are also mentioned in union list. So here we say the power vests with center. As we know, most of the thing or most of the conflict happens where the finance is have a significant role. Generally, we see most of the grants come from the union to the state government. So the matters related to finance have been a bone of contention between the union and the state government. Before Niti Aayog, it was Planning Commission which used to decide on the allocation also, and that is the reason now we do not have Planning Commission. We have replaced it with Niti Aayog, but again things have not changed. So generally we see more powers vest with the center. You take any power right from bringing law on concurrent list, or we have many subjects which are not mentioned in either of the three lists, that is union list, state list and concurrent list. So we also have many matters which are left as residuary powers, and on those subjects it is only parliament which could bring law. So states have nothing to do with those subjects which are not mentioned in above three list. So obviously it is union government which has become more powerful, and it is the constitution which has made union government more powerful with respect to state governments. One is that the constitution guarantees more power with respect to the union list. Obviously it is the parliament which can make law on the subjects mentioned in the union list. The subjects mentioned in the concurrent list can also, in concurrent list generally both state government and union government will make laws, but where there is a conflict, on such law between union government and state governments, it is the union government's law would prevail. So here also union government, that is central government, has an overriding power with respect to the laws made by the state government. So we can sense that state government has a very limited powers to make law, that too on day-to-day administration, that too on not so important subjects, that is law and order, education, health. So these are the subjects which generally the state governments would make law. Here the parliament can make law which has a overriding power. We can also say that the residuary subjects which are not mentioned in either of these lists is under union government. The union government would make law on the residuary subjects also. యూనియన్ లిస్ట్లో చాలా ఇంపార్టెంట్ సబ్జెక్ట్స్ మెన్షన్ చేసిబడి ఉంది. ఇంపార్టెంట్ సబ్జెక్ట్స్తో పాటు ఎక్కువ సబ్జెక్ట్స్ కూడా యూనియన్ లిస్ట్లో ఉంది. ఏవైతే చాలా ప్రామినెంట్, చాలా సిగ్నిఫికెంట్ సబ్జెక్ట్స్ ఉంటాయో అవి యూనియన్ లిస్ట్లో మెన్షన్ చేయబడింది. రెసిడ్యూరీ అంటే ఏ సబ్జెక్ట్ అయితే ఈ మూడిట్లో మెన్షన్ చేయలేదో, యూనియన్ లిస్ట్లో, స్టేట్ లిస్ట్లో, కన్కరెంట్ లిస్ట్లో, ఈ మూడిట్లో మెన్షన్ చేయని సబ్జెక్ట్స్ వేరే చాలా ఉంటాయి. అలాంటి సబ్జెక్ట్స్ మీద ఒక చట్టం తీసుకొచ్చే బాధ్యత కూడా పార్లమెంట్ మీదనే ఉంది. పార్లమెంట్ మాత్రమే అలాంటి సబ్జెక్ట్స్ మీద చట్టాలు తీసుకురావచ్చు. కన్కరెంట్ లిస్ట్లో ఉన్న సబ్జెక్ట్స్కి యూనియన్ గవర్నమెంట్ మరియు స్టేట్ గవర్నమెంట్ రెండు చట్టాలు తీసుకురావచ్చు. కానీ ఎక్కడైతే కన్ఫ్లిక్ట్ వస్తుందో అక్కడ యూనియన్ గవర్నమెంట్ చట్టం మాత్రం ప్రివైల్ అవుతుంది, స్టేట్ గవర్నమెంట్ చట్టం అనేది అక్కడ వర్క్ చేయదు. సో యూనియన్ గవర్నమెంట్కి ఓవర్ రైడింగ్ పవర్ ఉంటుంది ఈ విషయంలో. అందుకే మనం చెప్తాము ఎక్కువ పవర్ అనేది యూనియన్ గవర్నమెంట్ దగ్గర ఉంటుంది. Unequal representation of states in Rajya Sabha. This is one of the unitary feature. So we have Lok Sabha and Rajya Sabha. As we said, bicameralism is a characteristic of federalism. Bicameralism అనేది ఒక ఫెడరలిజం యొక్క కన్సెప్ట్. అంటే ఉభయ సభలు, రెండు సభలు ఉంటాయి మనకు పార్లమెంట్లో, రాజ్యసభ మరియు లోక్సభ. రాజ్యసభ అనేది స్టేట్స్ని రిప్రజెంట్ చేస్తుంది, లోక్సభ అనేది ఒక ఇండియా మొత్తాన్ని రిప్రజెంట్ చేస్తుంది. సో లోక్సభ ఎలక్షన్స్ అనేది డైరెక్ట్ ఎలక్షన్స్. మనము ప్రతి స్టేట్ నుంచి ఒక కాన్స్టిట్యుయెన్సీ ఉంటుంది, ఆ కాన్స్టిట్యుయెన్సీ నుంచి మనము ఎలక్ట్ చేసి రిప్రజెంటేటివ్స్ని లోక్సభకి పంపిస్తాము. రాజ్యసభ అనేది ఎల్డర్ హౌస్, అది స్టేట్స్ని రిప్రజెంట్ చేస్తుంది. సో హియర్ why we say unequal representation? As we know, every state should be considered equally. That is what the concept of federalism is. Irrespective of its size, its population, all the states should have an equal representation in Rajya Sabha. That we generally do not follow. In United States of America, we have Senate, which is elder house. ఇక్కడ రాజ్యసభ ఎలా ఉందో అమెరికాలో సెనేట్ అంటాము. మనకి అమెరికాలో 50 స్టేట్స్ ఉంటాయి. ఆ 50 స్టేట్స్ నుండి ప్రతి స్టేట్ నుంచి ఇద్దరిని తీసుకుంటారు. సో సెనేట్లో 100 మెంబర్స్ ఉంటారు. సో ఇర్రెస్పెక్టివ్ ఆఫ్ ద సైజ్ పాపులేషన్, స్టేట్ యొక్క జోగ్రఫీ అది సైజ్ కానివ్వండి, అక్కడ ఉన్న పాపులేషన్ కానివ్వండి, అది పట్టించుకోకుండా ప్రతి స్టేట్ నుంచి ఇద్దరిని ఖచ్చితంగా రిప్రజెంట్ చేస్తారు సెనేట్లో. సో వీ డు నాట్ ఫాలో దిస్ కైండ్ ఆఫ్ ఫెడరలిజం. ఇన్ ఇండియా we have Rajya Sabha seats depending upon the population of the state. స్టేట్ యొక్క పాపులేషన్ అనేది నిర్ధారిస్తుంది ఎంతమంది అక్కడ నుంచి రాజ్యసభలో ఉంటారో. అండ్ వీ జనరలీ నో దట్ రాజ్యసభ ఈజ్ నాట్ పవర్ఫుల్ యాజ్ లోక్సభ. లోక్సభకి ఇంపార్టెంట్ ఫంక్షన్స్, ఇంపార్టెంట్ పవర్స్ ఉంటాయి. లోక్సభతో కంపేర్ చేస్తే రాజ్యసభకి చాలా వరకు తక్కువ పవర్స్ ఉంటాయి. ఇంపార్టెంట్ బిల్స్ తీసుకురండి, అన్నిటికంటే ఇంపార్టెంట్ మనీ బిల్ అనేది రాజ్యసభలో ఇంట్రొడ్యూస్ చేయలేము, లోక్సభలో ఇంట్రొడ్యూస్ చేస్తాము. సో దేర్ ఆర్ మెనీ సచ్ థింగ్స్ వేర్ లోక్సభ has been more powerful. Obviously it has to be because the people there are elected directly. The representatives of Lok Sabha, MPs, are elected directly by the people. So when we compare their powers with Rajya Sabha, indeed the Lok Sabha has more power. But what is concerning here is when we say bicameralism is a characteristic feature of federalism, we do have bicameralism, but in that bicameralism, Rajya Sabha is weaker. We say Rajya Sabha has no power when compared to Lok Sabha. It has very lesser power. So the representation of the states in the upper house is based on the population. Unlike United States of America, in India, the members in the Rajya Sabha are dependent on the population of such states. Smaller the state, lesser the members in the Rajya Sabha. So we also have some states where only one member is represented in Rajya Sabha. That is simple, smaller states have lesser representation. UP is the largest state and most of the seats are occupied in the Rajya Sabha from the state of Uttar Pradesh. So this is one concept. So we can say that unequal representation is a unitary feature and which is not a federal feature. The executive is a part of the legislature. So who is the executive? Who is the executive here? We know ours is a parliamentary form of democracy, parliamentary form of government. We have not opted presidential form of government which is followed in United States of America. We have parliamentary form of government which is followed in England, Britain. So here the executive, as we know, we have three organs: legislative, executive and judiciary. These are independent to each other. Our constitution has mentioned it. we have 3 independent organs, though they are integrated but independent. So here the executive is a part of the legislature. We know we have a member of parliament, MPs, both from Lok Sabha and Rajya Sabha. Lok Sabha MPs are elected directly, and we have indirectly elected members in the Rajya Sabha. But those members only could become a part of the executive. That is what we have, representative form of democracy. The members of the parliament are the members who head the department or ministry. We have a ministry, we have a portfolio where under which minister is a member of Lok Sabha or Rajya Sabha, or if any such member who is not a member of either of the house can also become a minister, provided that within 6 months that member should be a part of either of the house. He or she may be elected to the Lok Sabha or nominated to the Rajya Sabha, but there is a time gap. Within 6 months of taking the charge as minister, that individual should be a part of the parliament. That is only provision what we have. Otherwise, no one can be minister after 6 months of the expiry date. So only 6 months is the grace period. Any individual who is not a minister or not a member of the parliament could only be an executive. Here when we say the executive is a part of the legislature, it means only the elected representative and a member of the parliament can be the executive. As we know, for any ministry, we have a political head and we have a administrative head. Administrative head would be a bureaucrat, maybe IAS, IPS. So a senior officer would be heading as the administrative head of that ministry or a department. And it is the minister who is a political head, and we call that political head as an executive. We have a cabinet form of government. Cabinet is nothing but we have a council of ministers. Council of ministers are the core members of parliament who will be heading such ministries or departments. Within the council of ministers, very strategic, important ministries are given to cabinet. So cabinet is a very powerful body within the council of ministers. They are the real executive. So here cabinet ministers and their portfolios, like we have defense ministry, home ministry, health ministry, we have law ministry, education ministry, agriculture ministry, all these external affairs ministry, finance ministry. So all these ministries which have a very strategic importance would be in the cabinet, and cabinet is a highest decision making body in the parliamentary form of government. So we say executives and legislatures are interlinked. So again here this is a unitary feature of the Indian government or Indian administration, where the federalism, the concept of federalism has been narrowed. So federalism is where the states and union have co-equal powers, but the central government, as we say in the earlier feature, central government is more powerful, and it is the union government which is a highest decision making body, and those ministers are the members of the parliament. So definitely there is an upper hand given to the union government. So this concept of having the executive part of the legislature is against the principle of division of powers between different government. So here definitely the state's power has been undermined. Going to next feature, Lok Sabha is more powerful than the Rajya Sabha. This we have understood because Lok Sabha is a directly elected body, and in numbers also Lok Sabha has at least double of the members in the Rajya Sabha, and Lok Sabha has many important functions to do. When there is a joint sitting also, obviously it is the Lok Sabha which prevails. So in unitary features, when we gave more powers to the Lok Sabha, it is against the federalism concept. As we say, bicameralism is a federal concept. We do have bicameralism in the name of Lok Sabha and the Rajya Sabha, but here Lok Sabha is more powerful than Rajya Sabha. Rajya Sabha is representing the state and Lok Sabha is representing the union. So here states or the units have been undermined. They have very less power when compared to Lok Sabha. So unequal powers will be against the concept of federalism. So Lok Sabha is powerful and that is the why we call it as a unitary features. Emergency power. This is a very important aspect. As in our constitution, we said that India as a unity, India as an entity can become unitary government or federal government depending upon the circumstances. Circumstances in sense when there is a breakdown of constitutional machinery or when there is a threat of war or external aggression, we generally transform or shift to unitary form of government, and emergency powers with the union government will make it possible or simple. Without changing the constitution, without amending the constitution, just using Article 352, Article 356 and Article 360, national emergency, President's rule, that is internal emergency and financial emergency. These are the articles through which the normal conditions of the India would change. Normally, we have parliament which bring laws on national important subjects mentioned in the union list, and we have autonomous state governments where the people in the state would elect the MLAs or members of the legislative assembly. So states also have equal significance, equal importance, and constitution itself given the power to the state governments. But in times of emergency, those directly elected body in assembly would dissolve. That is, the parliament can become the only authority in entire nation which could bring law on all entire union, that is entire India. So the emergency provision is in the hands of the union government. Through president, the government can bring emergency provisions. They can apply, that is, they can impose national emergency. The government can also impose through president the president's rule and financial emergency. We have not experienced a financial emergency till date, but this article, Article 356, has been most used article. Actually, it is most misused article because president's rule undermines the autonomy of the state, the independency of the state. It might be a political vendetta where the president, by the aid and advice of the cabinet, could impose president's rule. And we have seen in history many times. We have seen in Bihar, in erstwhile Andhra Pradesh, in Tamil Nadu, in many states, we generally see president rule which undermines or overrides the democracy at the state level. So when without amending or without changing the constitution, we have these articles where there is a smooth transformation from federalism to unitarism. So this undermines the provision of emergency, undermines the autonomy of the states. This is exception. Nowhere we generally find this kind of provisions mentioned in the constitution, where the constitution itself gives powers to the union government. So emergency power is a feature of unitary government. This is one thing. When we say the feature of federalism, it is independency of the judiciary. Federalism concept itself says that the powers of judiciary should be independent. There has to be a separate judiciary for the union government and separate for state governments, because it is the judiciary ultimately which interprets the constitution. In our case, we have independent but integrated judiciary. In United States of America, there is a separate judiciary for federal government and separate for provincial governments, that is regional governments or state governments. But in our case, we have integrated judiciary. We have a Supreme Court at the top level, then high courts, then district courts, then all other courts. So, Supreme Court supervises the entire judiciary system. Everything in the judiciary has to be supervised or administratively supervised, superintended by the Supreme Court. We call it as a apex court. So, right from appointment, transfer and all those day-to-day administration is supervised by the Supreme Court. So, where is the question? Where is the question of autonomy? So, we generally do not think there is a autonomy given to the states. Had we had a separate judiciary for the states, for example, we have high courts, but they also directly functions under the superintendence of Supreme Court. So, we say we do not have independent judiciary. Independent judiciary is a federal feature. We have integrated judiciary, and Supreme Court rests in the national capital Delhi, and the judges of the Supreme Court like Chief Justice of India, various judges of Supreme Court, judges of High Court are appointed by the President. So, President obviously is a national figure. He represents the nation. So, this becomes a unitary feature. Integrated judiciary becomes a unitary feature. Had it been independent judiciary, we would have considered it as a federal feature. But in India, though it is independent in sense, it derives its power from the constitution, and it has to be working independently from other two organs, that is legislature and executive. In that case, it is independent, but not horizontally. But we say here we have this concept of hierarchy in the judiciary, so they are integrated at all the levels, and Supreme Court is the highest court, so it is integrated, and this is a unitary feature. We do not have separate courts for the states. We would be discussing the unitary features. This is another important concept. We do not have dual citizenship. When we say characteristic features of federalism, dual citizenship is the feature of federalism. In United States of America, they have dual citizenship. The citizens have dual citizenship. One is a federal citizenship, and for states also they have another citizenship. So, they have dual citizenship. But in our case, in India, we have a single citizenship both for the union and the state government. So, once we have enrolled, we do not have other citizenship for state, single citizenship. We say we can move anywhere, we can settle anywhere, we can start our business or occupation anywhere irrespective of the place of birth. So, this single citizenship we can settle anywhere in any state. So, entire thing of providing citizenship holds in the hand of union government. It rests in the hand of union government. So, we have only single citizenship and no citizenship exclusively available for the state. So, it is a unitary feature. Obviously, we can understand that this promotes integrity, unity among the citizens of India. But here when we say federalism, as we are talking about federalism, this concept of single citizenship goes against the values of federalism. Governor's appointment, very important and very controversial area where governor is appointed by the center, that is union. We have a governor who is a nominal head in the state. We have a directly elected assembly where one of the member from the directly elected body would become a chief minister, and in assembly also we have council of ministers, we have cabinet ministers, but we also have a nominal head in the name of governor. And governor is again appointed by the union government through president. So the concept of governor who is not directly elected but just handpicked and nominated by the union government would become a bone of contention when there is no good relation between the union and the states. That is the reason why we call governor as an agent of the union in the state. Governor acts as an agent. Though governor has many power, he has many discretionary power other than the powers given or provided in the constitution. The post of governor has generally been misused because we see there are many cases in Supreme Court who have challenged the powers of the governor. So the interstate relation or the center-state relation has been undermined because governor is not directly elected but nominated by the union government. In America, every state has a directly elected governor. The governor of the state has been directly elected by the people. We do not have a concept as agent of federal government in the state government. But in India, as we know, the election process is very costly. So we thought that governor should be just nominated by the union. As we know, we are more towards a unitary state. So governor is a person who generally becomes a link between the union government and the state government. If there is any bill or any act which goes contradictory to the constitution, such bills, by using the power of governor to uphold or to withhold such bills, and he generally using those veto power will withhold such bill and send it to the president. President has absolute veto to stay such bills. So we call governor as an agent of the union government in the states. The state government does not appoint the governor, but the center appoints. So center has become more powerful here. So the governor, and generally the governor should not be the person from that state. It is generally followed thing where the governor should be from other states. So here governor's appointment is again a unitary feature. New states formation. See, when we read about federalism, it is the autonomy of the states. We know our country, India, when we say federalism, it is indestructible union with destructible states. Here, states do not have integrity. They can be changed. New states can be created, or two states can be merged. The boundaries can be altered. The names can be changed. So we have indestructible union with destructible states. That is the concept we have. In United States of America, there is different concept. States can come out of the agreement because they have formed union by agreement. So here, new states formation, only Parliament has the exclusive power to bring those bills related to formation of new states or changing the boundaries, changing the name. It is nothing to do with the states concerned. Obviously, the Parliament or the President would send a notice to the states asking for their opinion, but the opinion is not binding on the union government. We have All India services. Every country has, where we have followed the concept of federalism, where there is a union government and there is a state government, there is a two-tier government. Every country has their federal services and provincial services. In our country, we also have central services and state services. But this is a unique feature to India. All India services are those services which are common to both center and the state. We have three All India services here: Indian Administrative Services, that is IAS, Indian Police Services, IPS, and Indian Forest Services, IFS. So these services are recruited and trained by the central government but posted to the state governments. So, all India services also become a link between the union government and the state government. The members of All India services would ensure that the union policies or the programs framed by the union government, we generally call those as centrally sponsored schemes. So, these centrally sponsored schemes are to be implemented in all the states uniformly. So, to maintain that uniformity, we need such services. But again, when we say when these services are common to both union government and state government, it would definitely undermine the concept of federalism. It would undermine the concept of autonomy given to the states. And there were lot of things which have said that Indian services or All India services has undermined the state's autonomy. Even the Finance Commission, the 4th Finance Commission, which is a constitutional body headed by Rajmannar. So, Dr. Rajmannar committee has also said that this services has to be abolished. So, IAS, IPS, IFS, whatever the name, the All India services has to be abolished. But looking at the integrity of the nation and looking at the diversity of the nation, we need to have such services. One thing is it will bring uniformity among all the states, it reduces the equality, it promotes the feeling of nationalism, patriotism, it promotes the feeling of unity, integrity. So, obviously, we need to have those services. These are the services which are recruited and trained by the union government, but given posted to the states, but the ultimate action, disciplinary action would be taken by the union government. The state government would take in only a basic things. So, though the powers has lies with the state government in disciplinary action, but the ultimate action would be taken by the union government. So, these services offer uniformity in administration throughout the nation, but may not be in the interest of the state governments. That is the reason why many people or many states has thought of abolishing these All India services. Integrated election machinery. As we know, Article 324, we have a common election machinery for both union government and the state government. So, the power to conduct elections, the power to prepare electoral rolls, the power to settle disputes also, to supervise and to conduct free and fair election. It is the Election Commission. It is a constitutional independent body. So, the members of Election Commission are also appointed by the President, and obviously the President appoints on the advice of the union government. That is the reason why we say the Election Commission of India is a unitary feature. The Election Commission of India, ECI, conducts elections to Parliament, to both the houses, to the Lok Sabha and to the Rajya Sabha. It also conducts elections to the state assemblies also, and where we have bicameralism at the state level, it also conducts elections to the MLCs, that is corporation councils. So, here MLA and MLC elections, MPs both Rajya Sabha and Lok Sabha, and elections of President of India. Elections to the President of India and Vice President also conducted by the Election Commission, which is common to both union and state government. We have State Election Commission also. We have State Election Commission, which is under Article 243K. So, State Election Commission generally conducts election for local governments, that is municipals and panchayats, but at the assembly level, at the state level, it is Election Commission of India which conducts election, and all those things which governs Election Commission of India, right from qualification, their term, their disciplinary action, all these lies in the hands of the Parliament. So, Parliament could bring many such provisions which gives powers to the Election Commission of India. So we say that Election Commission of India is a unitary feature because it's common to both union government and state governments. So the members of the Election Commission are appointed by the President, and the Chief Election Commissioner is a powerful authority. No one could remove the election commissioners if it is a 3-member body or multi-member body. It is not easy to remember the members of Election Commission without having opinion taken by the Chief Election Commissioner. So it's a pure unitary feature when we say regarding Election Commission of India. This is again an important feature, that is unitary feature, veto over state bills. As we generally know, the governor will withhold certain bills passed by the state assembly. It might be, those bills might be against the values of the constitution, or it might not be in the interest of the larger section of the society. So the governor would generally veto such bills, having his discretionary powers. The same bill can also be sent to the president. గవర్నర్ అలాంటి బిల్ని ప్రెసిడెంట్ని కూడా పంపించవచ్చు. ప్రెసిడెంట్ దగ్గర కూడా అబ్సల్యూట్ వీటో ఉంటుంది. ఒకసారి అసెంబ్లీ బిల్ పాస్ చేసిన తర్వాత అలాంటి బిల్ని గవర్నర్ ప్రెసిడెంట్స్ కన్సిడరేషన్కి పంపిస్తారు. సో ప్రెసిడెంట్ ఆ బిల్స్ని మళ్ళీ తిరిగి అసెంబ్లీకి పంపించవచ్చు ఏదైనా చేంజెస్ చేయమని. అదర్వైజ్ ఇఫ్ ద సేమ్ బిల్ ఈజ్ presented to the president again, the president may or may not return the bill, or he may not pass the bill. So president has absolute veto. Because president is the union head, it would generally be a unitary feature in not considering the bills passed by the state assembly. So that provision undermines the concept of federalism. So the president enjoys absolute veto here. After reconsideration also from state assembly, the president may stop the bill with him, may keep the bill with him. So he enjoys absolute veto, and this is against the concept of federalism. Moving to another unitary feature, audit machinery. That is, we have integrated auditing machinery. We have CAG, that is Comptroller and Auditor General, under Article 148. We have a common auditing machinery both for union and state governments. So single authority would audit the accounts of both union governments and state governments as well. So the accounts of the state is also maintained by the CAG. So here one constitutional authority, union authority, would audit the accounts of state governments. So this shows that states do not have financial independency, because the constitutional authority, the union government, because CAG is appointed by the president again, so CAG will audit the accounts of the state government. So we can easily say that this undermines the financial autonomy of the state governments. The accounts of union government and state government, where the state generally should have an autonomy to spend their budget as the requirement of those states, but because of the fear of CAG, most of the policies of the state government would not be implemented. So integrated audit machinery is a feature, unitary feature, and not a federal feature. We have another important thing, that is power to remove key officials. Key officials are generally appointed by the union government only, because we know the union government through president appoints election commission chairman, members of the election commission, members of the Union Public Service Commission, chairman of the Union Public Service Commission, and members of the State Public Service Commission, CAG, Attorney General, Advocate General. So all those things are appointed by the president, that is union government. And obviously in judiciary also, right from the Chief Justice of India to the judges of High Court, every judge is appointed by the president on the aid and advice of the union government, that is the cabinet, the powerful decision making authority. So here to appoint and to remove key officials is also within the hands of union government, which undermines the concept of federalism. Here union government has become more powerful. They could appoint or they could remove any official. We have a process to remove the Chief Justice of India, to remove the chairman of UPSC, or to remove the election commission member. There has to be a process which is followed in the parliament. Parliament, again, the bill should be passed, for example, on various grounds of misbehavior, incapacity. So on all these grounds, these officials would be removed, and those officials are removed by the parliament. So parliament has unilaterally has powers to remove such key officials without taking any advice or any suggestions from the state government. So this provision is also against the feature of federalism, and here this is a unitary feature, giving more power to the union government. So as we have discussed all these things, unitary features, we need to also criticize what this federalism is, why we have opted federalism. All the features has been provided to the union government, all the powers has been given to the union government. What Dr. B.R. Ambedkar has said in the Constituent Assembly or in the Assembly is, we are not the federalism as in United States of America. Article 1 of Indian Constitution says that India is a union of states. We are not here by agreement. We are not came together by agreement. So we call this as a holding together federalism, not coming together federalism. So whatever the question of being centralized or giving more power to the union government, the basis of this criticism has been exaggerated. In the words of B.R. Ambedkar, he says that the critics said that there is an exaggeration, saying the power has been given, more power has been given to the union government. We know the main power is to having a legislative power. In our system, we have two-tier system. We have union government and state government. State government has its own legislative body, that is assembly. Union government has its own legislative body, parliament. So state government independently, autonomously can bring law. There is no interference of union government in the matters of state legislative assembly in normal conditions. We have exceptions. Obviously, we have exceptions. Under exceptional conditions or emergency conditions, we have a provision mentioned in the Constitution by Article 352, 356 and 360 imposing emergency, where there is a transformation of entire system from federation to unitary. So that is exceptions, and Supreme Court also says that exceptions are not rules. So in abnormal circumstances where we have threat to our constitution or threat to the democracy, threat to the sovereignty or secularism of the nation, obviously the union government becomes more powerful. The state assemblies would be kept under suspension, giving law making power to the parliament. So that is under exceptional conditions. We could not say that our country is not following any federal feature. Obviously we are following, but sensing the abnormal circumstances, constitution itself given the power to the union government. And we also say that our constitution is the source of power for both union government and state governments as well. So the critics generally say that the state government works under the union government. This is wrong. The state government and the union government derives their power from the constitution. Constitution is the ultimate source of power. It is the supreme authority. So here we cannot say that we do not follow the concept of federalism. So federalism is obviously followed, but we agree that most of the provisions are bent towards the union government. As the critics, K.C. Ware, also says that Indian federalism is not pure federalism. We have a quasi-federalism type. So, we are not pure, we have quasi-federalism. Even many thinkers like we have Maurice Jones. Maurice Jones have said that Indian federalism is a bargaining federalism. So, bargaining federalism is a concept coined by Maurice Jones, who says that when there is unequal distribution of power between union government and the state government would generally appeal to the union government for giving more powers, and that is what generally happens in India. Many state governments would ask for more grants from union government depending upon their financial conditions, and union government also, taking the recommendation of various constitutional bodies like Finance Commission, it will devolve finances to the state governments. So, we have a bargaining concept of federalism. So, here we cannot ultimately say that India does not follow the concept of federalism, and we cannot say that we have a unitary concept of system. We say that we have a bargaining federalism. That is what Maurice Jones have called. Another author, we say, another thinker, Granville Austin. Granville Austin has termed Indian federation as cooperative federalism. This is very much important. The concept of cooperative federalism. So, what we have, what the system we generally follow today is cooperative federalism, where both union government and state government cooperate each other on various matters, on various subjects, because we have such a diversity in our country. We have multi-religious population, we have diversity in terms of geography. So, all these factors would generally tend the union government to cooperate with the state governments. So, state governments has its own subjects, it has its own matters which are mentioned in the state list, and many provisions which is a concern for entire nation would be generally decided by the union government by taking support of the state government. So, recently we have GST Council bringing GST. GST is again collection of the taxes, which is a lifeline for any administration, and we have followed cooperative federalism in devolving the financial matters. So, GST Council, Interstate Council, so these are certain things where the union government and the state government come together and follow certain norms, not disturbing the fabric of integrity and unity. They would come on a platform, cooperate each other for the interest of the nation, for the development of the nation. So, as Granville Austin says, Indian federalism is a cooperative federalism. It is in a developing process. Every matter should be taken in a unique way and should be getting a solution. We have many problems, like we have states disputes, we have water disputes. So, all those disputes would be solved with a very cordial manner, with consensus developing between the state and union government. So, we generally follow cooperative federalism. So, the concept of federalism is not that, as critics say, India do not follow federalism or India is totally a unitary state. Though we have a concept of federalism which is a sui generis, that is unique to India, we also have upheld the concept of autonomy or independency of the state in various matters. So, by this we would finishing the concept of federalism. We have a quick check here. So, few questions just to understand the concept. Which among the following are examples of coming together federalism? As I said, coming together federalism is where small units, weaker units, maybe economically weaker or militarily weaker, would come together to form a strong union. That is coming together federalism. In India, we have a holding together federalism. The small states are not by agreement. So we have divided the states for our convenience and we have hold it together. So here coming together federalism, India is a holding together federalism. So this will not the answer. Again, this will not the answer. We have an answer here. United States, Switzerland and Australia, which follow the pure concept of federalism, where there is a autonomy, complete autonomy given to the smaller units, will follow the coming together federalism. So coming together federalism is followed in United States of America, Switzerland and Australia. India follows holding together federalism. So we have a concept of holding together federalism. So this is one question. So we have holding together federalism. What are the features of this holding together federalism? A large country divides its power between the constituent states and the national government. This is one thing. A large country divides its power between the smaller states, that is territories. The central government tends to be more powerful vis-a-vis the states. So obviously when we say the holding together federalism, we have the central government more powerful because it is more bent towards the union. All the constituent states usually have equal powers. This is a wrong statement because when we say the central government tends to be more powerful, then obviously this statement is wrong. The states do not have equal powers, they have unequal powers. Constituent states have unequal powers. This is true statement. So answer would be A, B and D. This is the answer. Constituent states usually do not have equal powers because holding together federalism gives more power to the union government. So the union list includes subjects. So what are the subjects the union list has? Union list, as we have discussed, union list has more important subjects and most of the subjects are with the union list. Education, forest, marriage, these are the state subjects. Police, day-to-day administration, commerce, agriculture, irrigation, state subjects. Residuary subjects like computer software, this is also union subjects. Most of the subjects are given to the union government. In concurrent list also union government could make laws. But the important subjects like defense, foreign affairs, banking, currency, communications, these are the important strategic subjects mentioned in the union list. So the union list includes subjects like defense, foreign affairs, banking, currency and communication. So this would be the answer. This is a bit larger question. Let's see this. Consider the following statements on the practice of federalism in India. Identify those which hold true for decentralization after 1992. See, that is by 73rd and 74th Amendment Act, we have brought local self-government. So local self-government is again a feature of federalism because we are giving autonomy to governing bodies, self-government. So local governments did not have any power or resources of their own. After 1992, local governments had power, had resources. They would decide on their own resources. So this statement is wrong. They had power. It became constitutionally mandatory to hold regular elections to local governments. Yes, this is correct statement because after 73rd and 74th Amendment Act, we have Article 243K, which brings mandatory to conduct periodical elections at local level. The state governments are required to share some power and revenue with local government bodies. Yes, this is also true because when we say powers to the local government, that is under Article 243P, the panchayats should be given power to the local governments, or the state government should give power to decentralize. That is the concept of decentralize, where the state government should delegate certain powers or to devolve certain revenues to the local government. So this statement also holds true. No seats are reserved in the elected bodies for scheduled castes, scheduled tribes and other backward classes. So this statement is wrong. Seats are reserved. Seats are reserved under Article 243. Under Article 243D, the states, the constitution has provided for the reservation in panchayats, and again under article 243 T for municipalities. So these are the two articles which provides reservation for the scheduled caste, scheduled tribes at local body elections. So we can say that this statement is wrong and this statement is wrong. So answer is B and C. Moving on to the next question. Which of the following governments has two or more levels? The entire class depends on this topic, where we say there are two independent units, two or more independent units. It has to be a federal government. So federalism is where we have independent autonomous units deriving their power from constitution. So this is the end of our topic, federalism. We would be coming up with next topic, next important topic. Do watch my videos. Thank you.